One thing I can say about Sarah Boone's lawyer is that he is not giving up. Today was day 5 of the Sarah Boone trial, and it is spicing up because the defense attorney is not having it. He thinks that he is going to be able to win this trial by, in my opinion, just delaying it by making frivolous arguments. If you guys were watching day 5 of the trial, you know that we are almost to the end. We got the last witness going forward. We got some rebuttal witnesses going forward. And we are working on watching some videos that are being presented to the jury without anyone on the stand. So that's interesting. Today is going to be a recap, a live stream where we're going to go over what happened today. We're going to watch a little bit of the argument from the from the defense attorney accusing the prosecution of being like corrupt and not giving them information that they were entitled to. And we're going to see the judge get a little bit irritated. We're going to watch a little bit of Dr. Warner's testimony to see what exactly she said that set the defense off and made them think that she somehow changed her opinion. I am going to start off by saying I do not think she changed her opinion at all. Her opinion was vague in the deposition, and her opinion was vague on the stand. Y'all can let me know what y'all think. If you guys have not been watching the recaps for the last couple of days, we are changing up the format. So we are going to go through the content and then we're going to do the chat at the end of the live stream. So feel free to continue to drop your comments and thoughts about the live, or not about the live, but about the case. And we will get to it at the end of the live stream. So again, let's go ahead and actually set a like goal since this is one of our normally streaming days. We are at 8 likes with 7 people watching live. So if you haven't already, please do hit the like button. We are going to set the like goal for the stream at 50 likes. So let's see if we can reach 50 likes today. I'm going to go ahead and jump right into it. We're going to start off with the testimony from Dr. Werner, and then we will get into the defense's obnoxious arguments regarding the change in her testimony. What it sounds like to me is that he's losing and he's trying to cause a distraction. I'll have to say, on her testimony, there was a lot of interruption, both on the prosecution side and on the defense's side. So let's have Bossy B bring us in. All right, so we are talking about Dr. Werner. She is a psychiatrist. Remember, yesterday we talked about the 2 psychologists that the defense brought in to testify for the court and for the jury. This lady instead is a psychiatrist, and she was brought in by the prosecution to testify to her expertness. Now, I will say I had a lot of problem with the defense and their expert, and the fact that they did not actually ask for their expert to be considered an expert. They did for the first one, it got denied, and then they just didn't for the second one. One thing that might surprise you and that surprised me is that the prosecution also did not ask to qualify her as an expert. I don't know why they're bringing these medical professionals that they're probably paying a lot of money and not qualifying them as an expert. So we have Dr. Werner. She's a psychiatrist. She explained to us that the difference between the psychologist and the psychiatrist is that the psychiatrist actually went to medical school and they can actually treat the disorders, while the psychologist does not go to medical school. But I mean, I guess they do therapy with people that have disorders. They can't actually treat and prescribe medication. Did not know that was a difference, but now we do, and we learned something new today. So let's go ahead and jump right into her testimony. Y'all let me know if y'all can hear it. I have it on 1.5 speed because we don't have time to be listening to how slow they be talking. So let me go ahead and play the video.
If you need them to refresh your memory, please do so, but don't read from them. Just let us know.
So she had a difficult time recalling what time they actually woke up that day. Initially, she said in the morning, and then she said she wasn't even sure that it was in the morning. She said that they both wanted to drink.
And
but that she asked that they could clean the house first instead, and that they did some vacuuming and cleaning. They had a half a bottle of wine left over from the day before that they drank. She felt about 4 o'clock in the afternoon. They drank that out on the back porch. And she described that they had kind of 2 beach chairs out there and a dartboard, and that they kind of hung out there a lot on the back porch, spent time out there. They did a puzzle out there and completed that, and then did some kind of artwork.
One thing I can say about her testimony, I was listening to it on the way in the car on the way to work. She says so much, and it was very hard for me to listen. So I apologize in advance if y'all don't like the ums. I definitely don't like the ums, but she keeps on with the ums, and that's what we have to listen to today until they actually stop her from talking. I was actually happy when they stopped her from talking because the ums was really bothering me. Okay, so let's play it.
Felt like he was getting frustrated thinking about his life, that he had lost his job. And so she encouraged him to call his daughters, although she knew that that they did not like to talk to him when he was drinking. So I'm not sure why she had encouraged him to call them at that point, because they were already drinking. And she also at some point encouraged him to call his brother because she wanted him to explain to his brother that he had pulled her down the stairs the night before, although that didn't happen. He didn't explain that to the brother, and according to her. And then at some point they went and got another bottle of wine and some cigarettes from the grocery store and continued to drink. And then they were inside the house, and then he, I guess, tagged her at some point and said, "Tag, you're it," which indicated that they were going to play hide and seek. And she said she went upstairs and hid in the shower and waited for him to come, and he never came upstairs. Excuse me. And so she eventually came out of the shower to look for him. And as she was coming down the stairs, she said she saw him slipping into a suitcase, which was on the living room floor, that they had put out because they were going to donate it. And sorry. And so she went downstairs and indicated that she had found him, and they were kind of laughing. And she zipped the suitcase up, and they continued to laugh, she said, at that point. And they were having a good time and laughing.
And so what I would say about Sarah is that her story of what happened during the day has continued to stay consistent, especially indicating, look, now I'm doing it. God dang it, Dr. Werner, you got me saying now. Jeez Louise. She has been consistent about her story of what happened during the day. What I like that Dr. Werner did here was she gave a little bit more detail about why Sarah was encouraging him to call his family. And, you know, when Sarah was testifying, she tried to make it seem like, oh, I was doing good. I want to make sure he has a good relationship with his daughters and his son and make sure they want to talk to him. But at the same time, she encouraged him to call his daughters while he was drunk, knowing that his daughters do not like to speak with him when he's drunk. And then we hear about from the brother testifying that she was yelling in the background, though, tell him about how you choked me. And the reason why she was doing it, she's the one that encouraged him to call the brother. And then she's causing all of this drama. Thought y'all was having a good day. Thought y'all just cleaned up. So why are you now causing this drama with the brother? I like that she gave us a little bit more detail. When Sarah talked about it, it was like unclear. When the brother talked about it, it was unclear. And now she's adding a little bit more context into it. Basically, I feel like she was trying to set him. Like when she was testifying, when Dr. Werner testified, I feel like now Sarah was trying to set him up for a bad time, if y'all know what I mean. I don't know if y'all got the same vibe, but that's the vibe I was getting from what Dr. Werner testified to.
And enjoying themselves and having a good time. And she said, and then she became angry. And she said she remembered what it felt like when he was choking her, and she became angry.
What did she do after she became angry?
I'm going to refer to my notes at this point.
While they were playing around. So nothing that triggered her. And she actually interviewed Sarah a couple weeks ago, not too long ago. This wasn't like right after the incident. This was more recently. And she's just now adding in that she got angry at him without.
She said that she shook the suitcase and that she lost control of it and it flipped.
And then what happened?
Then she said that he stuck 2 fingers out and her son's baseball bat was sitting there and she picked the bat up and hit his hand.
Then what happened?
And then she went upstairs and waited for him to come upstairs.
All right. Alcohol. Can you tell us what you know about the effects as a medical doctor of ethanol or alcohol on a human body?
Yes. So it causes intoxication, as we all know, and it causes disinhibition. It works on the frontal lobe of the brain. It allows us to do things that we wouldn't normally do. It disinhibits us.
And in the course of your practice,
let me stop.
Have you ever come across a diagnosis of alcohol abuse disorder?
Yes.
And what is that?
Well, alcohol abuse is an old disorder. So we used to use alcohol dependence and alcohol abuse. It's now been combined in the DSM-5. In the DSM-5 TR, it's alcohol use disorder.
In considering what a patient or a client or somebody that you ask to evaluate a government entity, do you take into account that person who's relaying the history to you a consumption of alcohol at the time of the history that they're given?
Yes.
Why is that?
Because again, it affects their behavior and their actions.
Does alcohol have any effect on a person's memory?
It can.
Absolutely.
What, if any, relationship is there between acute alcohol use or acute alcohol intoxication and battered spouse syndrome?
Again, it can affect your memory. It can affect your reactions. It can affect your response to different things.
Does the disinhibitory nature of alcohol strengthen, weaken, or have no effect on battered spouse syndrome?
It would depend on each individual again.
Generally speaking, it is important as an evaluator to get as much information as possible before rendering an opinion, such as diagnosing somebody with something out of DSM-5 TR or battered spouse syndrome.
Yes.
In this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening?
I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change.
What was your opinion?
My opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
And specifically talking about yes.
All right, we are approaching the bench here. Okay. So what is the issue that the defense is having with that particular statement? I don't know. When we get into his arguments about what his issue is, I don't think that she changed her testimony one bit. Y'all let me know if y'all disagree with me. You think that she changed her testimony. The question was, how do you come to your conclusion? I'm not going to say it verbatim, but how did you come to your conclusion? Would you need to consider anything additional? And what was your conclusion? She said what was your conclusion about Sarah having PTSD? If you watched the trial yesterday, the psychologist said that she had PTSD and that she fell into the category of battered spouse syndrome. When the prosecution just asked their expert, who is the psychologist, who is a doctor, and can treat these actual conditions, she stated that Sarah did not give her enough information for her to diagnose her with PTSD. That doesn't mean that she has PTSD. In my opinion, that statement doesn't mean that she has PTSD, and then it doesn't mean that she doesn't have it. It's kind of a neutral answer, in my opinion. Y'all can let me know if you think differently about it, but I don't think she did anything wrong by saying she did not give me enough information. It's just she did not have enough information in order to reach the conclusion that Sarah wanted. They're allowed to have differing opinions. Y'all let me know if I am misstating or I am mistaken and I don't know what the heck I'm talking about. And so we're going to jump into, I'm trying to find the point in the in the video that I'm trying to get to, in the defense arguing with his leg kicked up, thinking he's right about this. Let's have Bossy B bring us into the next part of the stream. Okay, so the defense has objected to the statement that Sarah did not give her enough information in order for her to diagnose Sarah with PTSD. If you remember from yesterday, Sarah's psychologist interviewed her 9 different times, and I don't know why I held up 3. That's not 9. Sarah's psychologist interviewed her 9 times, and this psychologist only met with her for 2.5 hours. So they may have gotten different amount of information. And then we also have to remember that Sarah's expert, who was not proffered as an expert, but neither was this one. So here we are. She had a little bit more time with Sarah in order to develop these opinions. Doesn't mean that this expert is wrong, but it just means she did not get that much as much information probably as the one that was hired by Sarah. So let's go on.
Every opinion she was going to express. It started on page 37, line 24. As it relates to Sarah Boone, do you have any diagnosis as it relates to her? And then 38 is when she started talking about a generalized anxiety disorder, and that she was not sure whether Sarah Boone had a generalized anxiety disorder versus if it was just an adjustment disorder to being in jail. And then she also mentioned in that same answer that Sarah Boone had some narcissistic personality traits, and that those were my 2 major diagnoses. And then I questioned her further about that. She explained again on line 17 about general anxiety disorder versus the adjustment disorder. And I hadn't had time to fully formulate that opinion out. Line 21, I need time to go through my notes and think about it and process it.
Page. We're still on page 38?
38, line 21. I need time to go through my notes, think about it, process it. But I had other depositions, as you're aware, yesterday, so I had to prepare for those, go through that. So I have not had time to process all my notes. And I said on line 39, well, doctor, I'm trying not to inconvenience you. We're set for trial October 7th for jury selection. Line 6, I anticipate your testimony would be until a little later. So we could discontinue the deposition.
So he's reading her deposition, and in her deposition, she told him that she had not had enough time to formulate the opinion about the PTSD. Similar to what she said on the stand, or I guess it's a little bit different. She said she hadn't had time to formulate it. And then on the stand, she said she didn't get enough information to diagnose her with PTSD. Either way it goes, the ultimate conclusion is that this psychiatrist did not diagnose her with PTSD. So I think his argument is kind of backwards with saying that, well, this is new information and I should have known about it. Well, you knew that she didn't diagnose her with PTSD when you did the deposition, right? You knew that at that time. So if you wanted to know whether she diagnosed her with PTSD, then you probably should have followed up with her a lot sooner than when she got on the stand, because you knew that wasn't a diagnosis from the deposition. I really wish somebody in the court would have pointed that out, but no one did. No one did but the psychiatrist. She's the only one that pointed out, like, my opinion has not changed. I did not diagnose her with PTSD. This is nothing new. But everyone else just kind of glossed over it, I guess.
And then reset it when you've got time to review. Because obviously I'm not going to want to take your deposition and you have other opinions that are not going to be covered. And then I asked, so Mr. J asked, what's your position? He said, conducting discovery after the jury trial starts is completely unacceptable to me. So that's my position. If she needs to issue a supplemental report, or if there has become a need for a second deposition, then we can address that. But it would be my position that we need to get this done because the state doesn't have any appellate rights once a jury is sworn and jeopardy attaches. And I say on line 23 of page 39, well, you obviously understand my position. I'd like to finish the deposition today as well. But if she is holding out that she may have other opinions and other diagnoses after she has had more time to think, review the paperwork, then obviously that creates an issue. And then she said, but if that happens, I can bring that forward. And then you can add to your deposition at that point if my opinions change after having reviewed further. And I refer to Mr. J. Page 9 of 40, Mr. J says, I think we plow ahead. This is our time with her. Court reporter's prepared to give us a transcript by the end of the week. Something needs to be amended.
End of the weekend.
End of the weekend. If something needs to be amended,
Correcting them.
then she can A, issue a report. B, if we need to take a deposition, an abbreviated deposition on the limited subject matter she is not prepared to testify about on today, then we can do that. But the notion of halting a deposition today that is set for 3 hours and then doing a 3-hour deposition during trial, especially after jeopardy is attached, is not what the state would do. Then I respond on page 40, line 23. I'm not suggesting that, Mr. J. I'm suggesting what you just said at the very beginning, which is let's finish. But if she has some supplement, then I would want to take a brief second deposition as it relates to any new diagnosis or opinions. Mr. J responds on line 4. Okay. What I'm understanding her to say is right now, there has been a previous diagnosis of an adjustment disorder in some of the records, and she just needs to review her records to see if she thinks that is the best diagnosis that she would give as opposed to a generalized anxiety disorder. And then the witness says, you essentially flipped that, Mr. J, upside down. You got that backwards. So we go on to page 42. Line 1, Mr. Owens, I agree. And Dr. Werner, just let the state attorney know.
Yeah, but we're skipping a massive portion of 41
Yeah.
that addresses specifically opinions as it relates to generalized anxiety
Thank
disorder.
you, Judge. Call him out.
15. So she's saying she has the generalized anxiety disorder, and I'm saying I want to review it more because Sarah Boone had disclosed to the doctor that she had been previously diagnosed with a generalized anxiety disorder. And so the Dr. Werner was considering that admission, but she was saying, I want to review it more to see if I think it's more of an adjustment disorder to being in jail, Judge, to being in the correctional setting right now. And that the stressors that she is under right now as opposed to a generalized anxiety disorder. So Mr. J says on line 22, okay, so on this topic, if something new comes up, then we can address it. But if you have other topics to post her on, then I suggest we go on. And then page 42, line 1, that's when I say, I agree, and Dr. Warner, just let the state attorney know. I know that you may be, we are on short time.
The prosecution's so annoyed.
If you do review your notes over the weekend or whatnot, and formulate any other opinions, just let the state attorney know, and I will address it.
We'll address it.
And we'll address it. Line 7, the witness.
Read the words on the paper.
And then, do you want me to continue reading, or?
If there's portions you want to highlight for me, I mean, I have the transcript. I'm following along with you.
That was the general understanding that we had about all diagnoses, all opinions that she may have. And so
he does not
she
get to the
starts talking
point
about the mental status exam that she gave her, and then she page 43, line A, she said she has narcissistic personality disorder traits. Or I asked that question.
Why do you keep highlighting that?
She goes through a little bit of that.
He does not have his argument together. He's flopping around trying to figure out what his point is going to be.
Paraphrasing, she talks about the grandiose component or criteria that she met. And then on page 45,
Judge is no longer reading along. Gotta catch up.
Which did indicate that she was a narcissist. And the answer, I didn't say that she was. I said that she has narcissistic traits, and that was the examples.
Excuse me for interrupting, but can we lasso this back into?
I understand that's what the depo reflects, but the non-objection which led to objection pertains to an opinion.
I'm happy that the state stood up and did that, because he was just going on like, are we going to read the entire transcript or are we going to move on at some point? You're just trying to, I don't know what his point was of reading that much of the transcript. You're not even talking about what she actually testified to. She hasn't even testified to any of that stuff. She hasn't testified to the generalized anxiety. She hasn't testified to the narcissism. She hasn't testified to any of that stuff yet. Yet he's bringing it up already, just confusing the issue. So the judge, again, for like the millionth time this trial, is going to have to reel him back in and get him back on the right track. So let's get it back into
specifically about post-traumatic stress disorder. At this time, no opinion is being referenced, nor does the call of the question pertain to narcissistic personality traits or diagnosis of narcissism. The question pertains to PTSD.
All right, page 46. Line 1, question, okay. Do you feel like she suffers from post-traumatic stress disorder? Line 3, answer. She didn't give me criteria with regards to that. She discussed having fear and anxiety of his family and fear that they would come into the jail or have someone else come to the jail and harm her. She talked about that. And she spoke about, having recollections, remembering abuse from George during the evaluation. Question 13, line 13, on 46. But you don't believe that she suffers from post-traumatic stress disorder, in your opinion? Answer, line 15. No. I would have to look back through my notes to see if she fully met the criteria.
Yes, that's exactly what she said.
Can you explain why you don't think she suffers from post-traumatic stress disorder? Answer, line 19. No, I didn't say one way or the other. I would have to look back through my notes for that.
She never said either way or the other.
You may, in the future, give an opinion about after some time reflecting and reviewing your notes. Line 24, answer, I may. Number 25, question, okay. And that's something you will let the lawyers know about if that changes. Answer, line 2 of page 47, yes.
Yeah, her answer didn't change, though.
That's specific to the post-traumatic stress disorder.
Okay.
So at the time of this deposition, when I asked her specifically.
So what's the legal objection?
Yes, what is the objection, sir?
What are the legal grounds of the objection?
I would not take that deposition, Judge. When she said I have not had time sufficiently to answer these questions, these diagnoses, these opinions, if this wasn't set for a definitive date that you had already told me it's not going to continue, I would refuse to take that deposition. But under the promises from the state,
what are the legal grounds of your objection? I'm familiar with the background. I'm familiar with the time frame. I'm familiar with all the dates and the depots and the coordination and everything we had to do to get this all teed up before trial. What are the legal grounds of your objection?
He doesn't have one, Judge. He doesn't have, it's not fair. That's his legal objection. This is not fair. I want you to tell the state to tell me all the answers and read the witness's mind. That's what I want. This is not fair, not fair. This is the defense attorney throwing a big tantrum like a big baby. He has been acting like throughout the entire freaking trial. Okay. It's not fair. That's my legal objection. It's just not fair. That's it. Do you not understand, Judge? She didn't change her opinion. She said, I would say the only thing that changed about her opinion is that she said she would need to review her notes to see if she qualified for PTSD. And so apparently after reviewing her notes and getting on the stand to testify in trial, she said she did not have enough information to diagnose her with PTSD. So just like she said in her deposition, she did not say either way whether she had it or she didn't have it. She said she didn't have enough information to come to that conclusion, which I mean, I guess that is the same. I said maybe that's different because she said she needed to review her notes, but that's the same thing as saying I don't have enough information at this present moment. And then after reviewing her notes, she doesn't have enough information, so she can't diagnose her with PTSD. You don't need your experts to say the same thing as the prosecution's experts. The prosecution wasn't like that when they didn't agree with the stuff that the psychologists were saying on behalf of the defense. They just handled it on the court, right? Handled it in court and did their cross-examination to pull out the information from those experts or from those professionals, because they didn't proffer them as experts, from those professionals that they needed to support their case. Why is the defense trying to throw a hissy fit and get rid of a witness? I don't know why, which we're going to get into. I'm kind of jumping ahead, but I don't know why he's trying to throw a hissy fit and just get rid of her as if he doesn't know how to challenge what she's saying on the stand. I think it's dumb. I think it's a really dumb move of them.
I understand the backdrop.
I mean, I don't know if there's a legal ground other than we had an agreement as attorneys, as parties, that I would be notified of change of opinion and I would be allowed to take a second.
Not a change of an opinion.
That's the only thing I know to object to, because I was not given that opportunity, which was an agreement between the parties.
Response.
Judge, I don't appreciate the implications that they're making.
Yeah, call me a liar.
What I would proffer with this witness is, we spoke yesterday. I asked her if she had any change in her opinion about any of the diagnoses. She said no.
Given the whole route.
I asked, well, then my position, my understanding of her position is that it doesn't matter whether she had PTSD or not, because what Ms. Boone said at the time was that she zipped Mr. Torres up into the suitcase. They were both laughing. And once he was already secured in the suitcase, she became angry and then did all the things that she did. My expected answers from the doctor, based on a very brief conversation yesterday and this morning, was that if I asked her whether or not PTSD or BSS had anything to do with this particular case, that her answer would be, it doesn't matter because of what she stated happened. I'm not asking her about her diagnosis of PTSD. I'm not going to be going into narcissism. I'm not going to go into whether or not she ever delineated the difference between adjustment disorder or anxiety, because my understanding of what she told me was that none of this matters. None of this matters because of what she said to us during the evaluation.
But the question was, and I may have to ask Madam Court Reporter to read it back, but my memory of what the question was is, have you formulated an opinion with regard to PTSD?
And my expected answer was, it doesn't matter because of what she said during the evaluation.
Okay. Unfortunately, that was not the answer that came from the witness. The answer was a definitive no.
Attorney's.
I'm not casting blame. I'm just going back over what was asked and what was said. Okay.
Yes.
Judge, and that's his position, that post-traumatic stress disorder, that doesn't apply in this case, and that he, I'm sure, reflected his opinion to the expert. But that doesn't mean that that's my opinion, that post-traumatic stress does not apply.
That's irrelevant for the purposes of this argument.
Nobody cares about your opinion.
As an officer of the court, he just told me, he spoke to the expert yesterday and the opinions hadn't changed.
And that's what he
And the
was
opinion that was
told.
offered at the deposition was, I'm not sure.
Information.
And based on what he had proffered as to what he expected the answer to be, the answer was not, it was not going to be any different.
The fact that the judge has to argue with you, you're the problem, okay? He was told by the witness, no, the testimony hasn't changed. While I still think it hasn't changed, it may have like a little bit more caveat to it, but her opinion still has not changed. She hasn't said whether she has PTSD or not, regardless, okay? Just because she didn't say, yes, she has PTSD, now the defense is mad. She's just saying, I don't know. Essentially is what she's saying on the stand, is that I don't know that she has PTSD, okay? And for you to get up there and say, oh, well, the state knew and they didn't tell me. Well, the witness told him that her testimony hasn't changed, because it hasn't. It has not. So I don't think that the state did anything wrong. I think we'll get to the Richardson hearing, but I don't think the state did anything wrong here. But defense is just, in my opinion, having a big old hissy fit right now.
It's not applicable. It doesn't matter because of what she told me. That's unfortunately not the answer that was given. So what is it that you're asking me to do at this time, Mr. Owens?
I'm asking, I don't know if we need to proffer the entire testimony of this witness, because opinions and diagnoses have apparently changed. I think I have a right to take a second deposition before she testifies.
What other opinions, Mr. J, if any, are going to be offered by Dr. Warner?
Can I just proffer?
Yes.
All right, you've been present for all this hearing. Yes, doctor? Yes. Am I misrepresenting any of our conversations?
No.
All right. And so if I asked you if battered spouse syndrome or PTSD has any relationship to the facts of the case as the defendant relayed them to you, what would be your answer?
That it's not related to the incident as she reported it.
Okay. And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be?
No.
And if you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening?
No.
That's it.
Judge, number one, she's giving a legal opinion. Number two, it's a discovery violation.
He's still mad. Now he knows what he's going to object to. It's a discovery violation. So when the court asked him, what's your objection? He didn't have an answer. Now he's just going to give it a kind of catch-all and call it a discovery violation. Like, I absolutely can't.
That's the legal opinion.
The post-traumatic stress disorder doesn't apply in this case.
Dr. Carver testified it did, and that's what experts do.
Right.
I would like to have known that, and that was going to be her opinion before today.
How did you not know that? How did you not know that was going to be her opinion?
Where is that a change in deposition?
It's not a change.
No. This is a 87-page transcript.
Figure it out and tell me what you want me to know.
To establish your objection.
Give me a minute. I'll read through it and find.
Establish your objection. And tell
this isn't the first time I've looked
give
at this
me a
deposition.
minute.
The state provided it to me when we had the hearing on whether or not battered spouse would be permitted. The state provided specific highlights for me to look at. At no point in time did the defense say, look at this, look at this, look at this in her deposition when we had that hearing. So other than what's being provided to me right now and what's been testified to this morning, I don't know what opinions she has. All I know in coming into today is what the basis of her opinion was, specifically with regard to any of the statements that Ms. Boone had provided.
And I ain't
Which is the
reading
whole
it for
crux
you.
of
I'm not
the
doing it
state's
for you.
motion to prevent battered spouse from coming into evidence.
Judge, if you look at page 66.
All right, here we go. Some
Mine's
more
fine.
reading for us that he's going to do and explain nothing at all.
Yes, sir.
Page 66, line 20, question. Okay, so other than the couple of hours that you intend to maybe reflect on your notes and anything else, any other work that you intend to do on this case? Answer 23, no, sir. Not that I'm aware of. Line 24, question. And you've expressed all your opinions, at least generally here today. Answer, page 67, line 1, yes, sir. Question. Then I go into these. Then on 67, line 7, question. Just double dog sure. You admit that you have no other opinions other than the ones you've expressed here today. Line 10, answer. That I've been asked about. If I'm asked something else, that I'll offer it. Number 12, question. And you've been provided all the resources you need to rely on and express your opinions. Line 14, answer. I have based an opinion on the resources that I've been provided.
On
If
what
there's
I
other things
have.
out there to be provided that may or may not change my opinion.
Let me know if I'm missing anything, is what she's saying. I don't get what he doesn't get. And how he doesn't feel dumb arguing this. It wasn't a change.
We had an agreement that I was going to be allowed to retake the deposition, not be ambushed in the middle of the trial with a new opinion.
What new opinions
Thank
are
you.
different based on what Mr. J proffered the testimony is going to be?
I have to ask Madam Clerk to reread the question and the answer from the experts.
You don't even know what you're
Madam Clerk,
arguing
Madam Clerk, were you able
about.
to reread the portion of the proffer as to what Mr. J asked of the witness?
You don't know what we're arguing about.
Absolutely. Of course.
The witness is looking like, what the hell is happening right now? He needs the court clerk to pull up and let us know what the heck they're actually arguing about. Isn't that insane? He done caused all this ruckus. He done read about 4 or 5 pages of the deposition, and he doesn't even know what the new evidence is that's being admitted. He's arguing that there's new evidence, but he can't tell the judge what the new evidence is. Her new evidence is the same as the other one, is that she does not have an opinion either way it goes, whether it is yes, she has PTSD, or no, she does not have PTSD. She specifically said that in the deposition. The only difference is that she said she needs to review her notes to see if she meets the criteria. Now she is on the stand saying she reviewed her notes and she doesn't. Sorry, there, she's pulling up the thing. She has reviewed her notes and she does not have enough information still. That's the opinion. It was literally the same opinion. I don't know what more he wanted her to do, them to say. I'm lost in it, okay? I'm lost. And I don't see how like the judge did not pick up on it either, and neither did prosecution, that it really hasn't changed. She said the same thing, and that was really irritating me as I was waiting for them to figure their stuff out. So let's go ahead and jump into the next part of this because they were on pause for quite a moment there. Get the judge back on the bench and see further into this argument what this guy has to say, because he's not doing a good job, in my opinion, but at least he's going to fight hard for his client. Like that's all he can do is zealous advocacy. And that is what the man is doing. Okay. I'm having technical difficulties at this point. Let's see. And because the video is loading. So actually we can't play it yet. Let me reload my whole screen. Let's bring this back up.
James Owens, Ms. Boone.
All right. So we are back in.
Ms. Boone is seated at counsel's table wearing the same clothing from this morning. Madam Court Reporter, have you had the opportunity to review the transcript as to the proffer of Dr. Werner's testimony? Okay, you may proceed.
Okay, let me get my life together here. Oh, this is on 1.5.
Mr. J, question. You've been present for all this hearing, yes, doctor? Answer, yes. Question. Am I misrepresenting any of our conversations? Answer, no. Question. All right, so if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case and the defendant relayed them to you, what would be your answer? Question. That it's not related to the incident that she recorded it. Question. Okay. And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. Question. If you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question? All right, that's it.
I don't think that's the very beginning, before I objected.
Isn't it? Yes,
was
it is.
asked
It's literally
was to read back the proffer.
I thought I was asking to go back to the very beginning when the question was asked and then her response.
that was
What was specifically asked was to the proffer, because the question before the court.
that was literally he was like, I don't think that came to right to the question right before it. That was literally what was said right before he objected, and he's saying he doesn't think so. Because what he realizes, which I'm mad that no one else called out but the psychiatrist, is that her opinion has not changed. When he listened back, he was like, oh, yeah, she still didn't make a decision whether she has PTSD or not. Yeah, no. He caught it. Of course, he's not going to tell on himself. Was that yesterday or was that today? Where the state made the argument for them regarding, it was yesterday, where the state made the argument for the defense about allowing in the what do you call it? What are they called? No contact orders, and made the proper arguments to the objection of hearsay. My guy said he has been doing this for over 35 years, okay? And he couldn't come up with that objection or that response to the objection to hearsay. Like, come on, dude. Even I knew that, and I'm a baby lawyer. Let's go.
Was whether the proffered opinions are at odds with what was testified to during the course of the deposition. There's the question that was asked and the answer that was given affirmatively provided an opinion as to PTSD. I think Mr. J admits that. Mr. J has advised the court that's not what he was hoping the answer would be. The answer was supposed to be something different, as identified in the proffer, which is why I had Madam Court Reporter read back the proffer. So the question Mr. Owens posed to you is whether the proffer opinions that Madam Court Reporter just read back to us are different than what was provided in the deposition.
Yes.
How so?
Why is nobody catching on to this?
Tended to explain in the proffer some legal reason why it did not apply. In her opinion, that was not discussed in any way in the deposition.
Okay. My question is specific as to opinions. Her opinions were as to battered spouse syndrome or post-traumatic stress disorder and their relationship to the case based on the defendant's responses. The answer is not related to the incident as the defendant reported. Those are the opinions, as I understand them based on the proffer, as it relates to battered spouse syndrome and post-traumatic stress disorder.
And that she did not get enough information to diagnose her with either one. That's what it is. I don't know why they keep skipping over that. He wrote down all that stuff and still didn't get to it. And this guy over here just, not even helping out, just looking like he's falling asleep at counsel's table. Help your buddy out.
I think I'd refer to page 46. Line 13 was the question, but you don't believe that she suffers from post-traumatic stress disorder in your opinion. Line 15, the answer is no. I would have to look back through my notes to see if she fully met that criteria.
Said no, and she explained
Question 17,
further.
can you explain why you don't think she suffers from post-traumatic stress disorder? Line 19, the answer no. I didn't say one way or the other.
Exactly.
I have to look back through my notes for that.
And she said the same thing on the stand.
Is that something that you may
How is that different?
Give an opinion about after some time reflecting and reviewing your notes? 24, I may. 25, okay, and that's something you will let the lawyers know about if that changes. That's on page 47. Line 2, yes. That's fundamentally, substantially, materially different from what she's testified as it relates to post-traumatic stress.
I don't think so.
In the proffer?
Excuse me?
In the proffer?
In the proffer?
She's not rendering it, unless I misunderstood the proffer, she's not rendering an opinion on PTSD and whether or not
Thank you,
Ms. Boone
Judge.
suffers from it.
Well, she led me to believe that she was trying to decide whether or not Sarah Boone suffered from post-traumatic stress. Now in the proffer, they're claiming that post-traumatic stress does not apply. I don't know what the initial question was. We haven't had that read back when it was first going on. When the question was asked.
The judge is just as shocked as we are.
We read back what the initial question was, what the response was, because it didn't. I know I objected. I can't even remember it now, but I know I objected because I knew it was inconsistent.
You asked to approach, and then you explained that the question was not something that was framed in the deposition. Multiple times I asked you for a legal objection. And it wasn't until right before or right after we sent the jury out that you provided some legal objection. Madam, if you want Madam Court Reporter to go back and read the question that led us to where we are right now and the answer, I'm totally on board with that. I have a memory of what it was, but nothing like.
Before she does that, can I get the first question of the proffer? If BSS or PTSD has any, can you reread that?
Let's just reread the entire proffer, just so that it's clear, soup to nuts, alpha to the omega,
God,
what the proffer was.
Y'all are stressing the court reporter out, man. Get her somebody else to help her. Why y'all doing that to my girl?
Mr. J, question. You've been present for all this hearing. Yes, doctor? Answer, yes. Question. Am I misrepresenting any of our conversations? Answer, no. Question. All right, so if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case as the defendant conveyed them to you, what would be your answer? Answer, that it's not related to the incident as she reported it. Question, okay. And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. And question, and if you reviewed any of the materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question, all right, that's it.
And then if you could go back to the initial.
Y'all asking for a lot of my girl at this point. She said the same thing she said in the testimony, is that she needed to review her notes to determine whether she meets the criteria. And now she's saying that after reviewing her notes, she can't say either way because she didn't get enough information. And the proffer, since she did not make a decision about the PTSD, the proffer is, even if she had PTSD, would it change? Did that apply? Did the PTSD apply to when this incident happened? And she's saying no, because of the happy nature that they were in right before it happened. And Sarah flipped the switch and got mad. So regardless of whether she has PTSD, what the prosecution is arguing, regardless of whether or not she's diagnosed with PTSD, it doesn't matter, because she still wasn't justified in what she did to George, which is what we've all been saying from the very beginning. Yes, they had a tumultuous relationship. Yes, they had a toxic relationship. But did that justify her leaving him in a suitcase overnight after he pleaded with her, telling her that he could not breathe? The answer is no. That's the psychiatrist's opinion, and the defense does not like it. So here we are, waiting on him to make more arguments. Don't know why, but this is what he decided to do on this day where we were supposed to be finishing up court, wasting an hour, 2 hours. And not only does he do this right before lunch, he then comes back and do it after lunch, which we're going to look at that part. I don't know if there's very much more to watch on this one, to tell you the truth, regarding what happens here. Let me see how much more this one has.
Oh, I was waiting on you. Please, go ahead. I'm sorry. Pay no attention to me. Go ahead. My understanding is it was the question and the answer right before Mr. Owens asked to approach.
Okay, so let me go ahead and pause this. I'm not going to watch the rest of the nonsense that they went through. I'm going to try to skip. So basically, they end up doing a Richardson hearing. The court finds that the state did not do it on purpose and not telling him of the new testimony. Again, I do not agree that it's new testimony, but the judge went ahead and said it's new testimony. So they found that the state did not do it on purpose, but it has interfered with the defense's opportunity to prepare for trial. And so the court asked what the defense would like the remedy to be. And the remedy that the defense is requesting is that the witness be stricken. Like, she cannot testify anymore, and everything that she says has to go out the window. You know why? Because he doesn't like what she said, and he doesn't want to have to remedy it and argue against it in closing, and also on his cross. His cross sucked. We're not going to watch the cross today, but in my opinion, the cross sucked. Okay. And so then we go forward, and he says, okay, well, would you like the statement stricken? The court says, I'm not going to strike the witness, but would you like that statement stricken? Again, I don't agree with that, because it was not a change of testimony at all. She didn't diagnose her with PTSD back then. She didn't say she had it. She said she didn't say she didn't have it. And again, today, she did not diagnose her with it. And she also didn't say that she didn't have it. She could potentially have it. So the remedy that the court offered was just to strike the statement. Again, I don't agree with that. And then the defense himself said no. He doesn't want to strike the statement because he wants to address it on cross. Do y'all think he addressed it on cross? No, he did not address it on cross at all. I don't know what he thought was going on. He thought he was going to be able to get around it or something, but he did not address it on cross. I thought that was very interesting. So what the court did to remedy the situation was allow the defense to question her, depose her right on the stand. And as they were going through the deposition on the stand, he kept stopping and arguing with the judge even more. I don't know what timestamp that is, and I did want to watch that. Okay, here we go. It's right here. Okay. So let's go ahead and watch him depose her on the stand and get frustrated with himself because he doesn't know what questions to ask, and then go from there. So we're going to skip the Richardson hearing. We are now in the court's remedy. So let's have Bossy B change. Okay, so we are now in the court's remedy, allowing the defense attorney to depose the witness while on the stand to get more information from her. And I'm going to tell y'all from the jump, she actually gave him some information that would be beneficial to his case. And then he didn't do it, or he didn't use it against her in his cross-examination. I don't know what this guy is doing. So let's see.
The deposition for you, Mr. Owens, to inquire as to those opinions.
I'm sorry.
With regard to the proffered opinions, the court will oversee a deposition now, and you may proceed.
Right here?
Yes. Ask her some questions.
With regard to the proffered opinions.
You got all them attorneys sitting up in
And
there.
I believe that will provide a cure for the discovery
for you.
violation under the Richardson violation based on your request not to strike a prior opinion. And since you're going to utilize that on cross, I find that the prejudice is limited. But with regard to the new opinions, I will give you the opportunity to depose her now, curing the prejudice at that point in time. You may proceed.
Dr. Warren.
Yes, sir.
Good morning.
Good morning.
At some point, the state attorney notified you that you were to come today.
Correct.
Did you and the state attorney have a discussion about your testimony?
Yes.
When was that discussion?
Briefly last night.
So y'all talked on the phone last night?
Yes.
Have y'all had any discussions since the phone conversation last night?
Briefly this morning.
And how long was the phone conversation?
Less than 5 minutes.
How long was the face-to-face conversation?
Less than 5 minutes.
Did y'all discuss that your testimony would be that you did not have enough information that you gathered from Sarah Boone to form an opinion as to whether or not she suffered from post-traumatic stress disorder?
Correct. That my opinion hadn't changed.
Yep.
I'm sorry?
She's right.
That my opinion hadn't changed. That I didn't have enough information.
Yep. She don't have enough information.
Okay.
She said that on the transcript. She did.
And did the state attorney speak to you about
In other words,
that it didn't matter whether you had an opinion if you didn't feel like the facts that Sarah Boone had given you as it relates to the facts and issue in this case, that you didn't, if you didn't feel like post-traumatic stress even applied, then you could answer that way.
Spit it out, buddy.
Correct. That was my opinion. Correct.
But did he present that to you initially for you to form an opinion about it?
No, my opinion was that it didn't apply because
Regardless.
of the way that she described the incident to me.
Was that your opinion back when I took your deposition?
Yes.
When did you form that opinion?
When she described the incident to me.
Why didn't you let us know that was your opinion at the time that I took your deposition?
You didn't ask me about that, sir.
Do you remember me asking
did,
you
but-
any other opinions that you may have as it
to
relates
review our
to
notes.
this case?
You didn't ask me specifically about that.
I understand that, but you're saying you formed that opinion
She's so sassy.
prior to the deposition, correct?
Yes. The state attorney and I discussed that on the way out of the jail, as a matter of fact,
No, this
After
is
the
not
deposition.
in front of the jury.
after the evaluation.
Okay.
On the way out of the jail.
All right, and I asked you, were there any other opinions that you may express at trial after you had discussed that with the state attorney prior to the deposition?
So
Is that correct?
He wants her to read his mind.
And so you were aware that I didn't want to be ambushed at trial. I wanted to know any and all opinions that you may be expressing in the Sarah Boone case.
You know what I wanted? This
I
is
didn't know
not
what
fair.
specific information you wanted, sir. That's why you had a deposition. I answered your questions. I don't know what all information you want me to,
Yes.
to provide to you.
So because I didn't ask you specifics, you felt like you didn't have to respond specifically.
I
Exactly.
answered all of your questions. And as I said, I'm happy to answer any questions that I'm asked.
Exactly.
I don't know what questions you want me to
He's
answer.
not
But you know
wrong.
that this was a central issue in the case.
And
Did you
she
not?
answered the question. I
Your
don't know why
your
they're skipping over
is
that.
relating to a central issue in this case.
Correct?
You're aware Sarah Boone's on trial for murder. And you had this opinion when I was taking your deposition, and I was asking you specifics about any opinions that you may be expressing in the trial of Sarah Boone, and you did not disclose it.
Well, I told you that I would answer any questions that were asked of me. I have a number of opinions. I know that I don't feel that she's suffering from major depressive disorder. I didn't offer that opinion either. I have a number of opinions.
That's all the questions I have.
Mr. J, anything else?
You got nowhere with that.
Want to inquire,
Nowhere.
This is your opportunity, Mr. Owens.
because that was more just about.
Inquire about what?
This is your opportunity to inquire. You are conducting a deposition.
Thank you.
This is
Judge.
your opportunity and your only opportunity to cure any prejudice that we've identified with regard to those proffered opinions as it relates to the relationship of battered spouse syndrome and or post-traumatic stress disorder as proffered.
The problem is now, judges, I've got my expert, and we weren't aware, you know how in these type cases, the experts are allowed to listen to the testimony of the other experts
Mhm.
and read the depositions of the other experts. Dr. Werner, were you given the opportunity to read Dr. Harper's deposition?
I was.
And that's standard operating procedure in these type cases. And now I'm taking a deposition on the fly. And then I haven't had a chance to speak with my expert about those opinions and whether or not that would change her opinion.
The judge is not entertained.
It just puts me in a very difficult situation. But
It's
if I'm
not
able
fair.
to continue the deposition, I will.
That's your decision. It's not an order. I'm just saying that this is the opportunity to cure that Richardson issue. You asked previously to strike the expert. I am disinclined to do that. The case law says that is an extraordinary remedy, one which I am not going to permit.
Dr. Werner, you realize you're in a courtroom.
He
and
just
we're waiting on the
ignored the
jury
judge.
on the trial of Sarah Boone.
Yes.
Are there any other opinions that you intend to express in this trial that you have not disclosed to me in the deposition, or you have not disclosed here today under oath?
Because you didn't answer the
Any
question?
questions that I've asked?
Are you refusing to answer my question about any other opinions that you intend to express here today as it relates to Sarah Boone, who was on trial for murder?
You were responsible for asking the questions that you needed to answer or to ask her. You didn't ask them. I think he did ask them and she gave him the same answer. But for whatever reason, everybody's skipping over it today, but her saying that, you know what, that's what I said. I'm sticking to it. And you didn't ask anything specific to whether it would apply to this particular case. So no, I didn't answer that question. But he's like, so you're not going to tell me what you're going to testify to that you didn't tell me at the deposition because I didn't ask you the question? No, that's not my fault. You didn't ask the right questions. Figure it out. You're the attorney.
In the second degree.
So I'm going to check the catch-all vague question that Mr. Owens wants to ask this expert witness about any and all opinions she may or may not have. 99 out of 100 attorneys will come in here and say that's not how you do depositions with experts.
It's not.
You have to ask specific questions. Anytime you ask a question like that of an expert, the expert is always going to say, please ask me a specific question.
Exactly.
And that's what she did then. That's what she's doing now. It's unfair.
That's what his expert did.
Ask somebody, tell me everything you have.
Tell me everything you know about life.
We're in the middle of a trial. She's fixing to testify. She's had conversations with the state attorney. She knows what she's going to be asked in terms of opinions.
She already
that she's going to
told you.
express. That's why she's here, to help the jury understand the science that relates to the law and express opinions.
She already
I mean, for
told
me
you
to
what she's
ask,
going to say.
we're playing hide the ball here in the middle of a trial.
I disagree that there's any hiding of the ball. There's been a proffer that's been read multiple times as to the scope of the opinions regarding to battered spouse syndrome and post-traumatic stress disorder and its
No,
relationship
I
to the
didn't
facts of the case as the defendant represented them. And the answer is they are not relatable to the incident as relayed by the defendant. That is the opinion that have been proffered.
Can I continue with my deposition?
Yes. You're the one that's
Dr. Werner,
confused.
You recall expressing that you wanted more time to reflect as to whether or not Sarah Boone suffered from post-traumatic stress disorder.
Yes, that I was going to review my notes to see if I had enough information in there to support or negate that.
What additional information would you need for you to express an opinion that she suffered from post-traumatic stress disorder?
So she did not give me information regarding the presence of intrusive symptoms. She didn't give me information regarding persistent avoidance. She didn't give me information regarding alterations in arousal or reactivity.
Anything else?
No.
Would you agree you failed to ask her those questions?
I asked her if there was any other important information that she felt like she needed to share with me at the end of my evaluation. She said no.
So a catch-all question.
Why? That
Were there any
was
other
messed up in my
personality
opinion, but
disorders?
whatever.
Isn't that what you do as a psychiatrist? You diagnose an opinion, express opinions about whether people suffer from personality disorders?
Right.
Are there any other personality disorders that you have formed opinions about Sarah Boone that you intend to express?
No.
So narcissism, you did not find.
I found narcissistic traits.
In terms of your opinion that she suffers from narcissistic personality disorder.
No, sir, I said narcissistic traits.
Okay. So you don't have an opinion that she
And
suffers from
that's-
narcissistic personality disorder.
She already
She
answered you.
she displays narcissistic traits.
You express an opinion that she suffers from alcohol use syndrome,
Alcohol use disorder.
alcohol use disorder.
Correct.
Is that still your opinion?
Yes, it is.
Anxiety disorder. Is it your opinion she suffers from the anxiety disorder?
No.
Nope. She said that too.
Do you recall in your deposition indicating that you felt like she suffered from either anxiety disorder or adjustment disorder?
That's correct.
And you changed that opinion now?
I have
Said either or.
I'm leaning towards a adjustment disorder secondary to her legal situation.
So you haven't formed an opinion as to whether or not she suffers from general anxiety disorder or adjustment disorder?
Correct.
No, she hasn't.
Do you agree that she
diagnosed.
suffered from trauma as it relates to the domestic violence history that she
And
expressed
this
to
part
you
is helpful
from the
to the
intimate partner
defense.
violence with George Torres?
Yes, as reported by her. Yes.
Do you have anything to dispute that?
No.
I think that part helps them because he's going to get into better. You'll see what happened. But this part of the questioning was actually beneficial to
In
him,
your
and he
opinion, does
didn't
she
use it
suffer
in
from
the
any form
trial.
of psychosis?
No.
And the jury is not here at this time. So
Is it your opinion that Sarah Boone suffers from acute stress disorder?
No.
Is it your opinion that Sarah Boone suffers from intimate partner violence?
Yes, I think that there is enough history of the volatile relationship between the two of them.
Because of that, do you believe that Sarah Boone suffers from battered spouse syndrome?
She may meet the criteria for that.
May.
Yep.
So
She's
it's possible.
very careful with her
Is that
words.
your opinion?
Yes.
Definitively, you can't say?
There's a history of her having that, yes.
So you agree she suffers from battered spouse syndrome?
Yeah.
So that helps the defense. He does not use it in trial, though. She literally said she suffers from battered spouse syndrome.
I believe we've covered anxiety disorder, narcissism, battered spouse syndrome, and alcohol use disorder.
My boy is
Are there any
sending
other
text
opinions that you
messages.
intend to express as it relates to that or any other psychological condition of Sarah Boone?
No.
That's all the questions I have.
Thank you. Thank you for finally being done, because you are all over the place at this point.
Any other arguments at this time?
No, Judge, just the one I've already made.
Okay, all right. The court has conducted its Richardson hearing and made its findings. The court, as previously identified, will not strike the expert, as that remedy is quite draconian, and I will not do so based on the questions that were asked as highlighted by the defense and the opinions that were offered. The specific areas for which opinions are being offered were not inquired into, but the deposition did leave it open that I'll ask questions about any other opinions that I'm asked about or anything that I'm asked during the course of the trial, specifically page 59, 22 through 26 on 1, page 60, lines 11 through 25. So in the abundance of caution, the court has permitted that in-court deposition. Anything else, sir?
No, sir.
State anything else?
No, sir.
All right, let's go ahead and bring back in our panel and we can,
Before we bring the jury back in, may I approach Mr. Cacciatore on a completely unrelated matter?
does it need to be on the record or?
Yes, it does.
Okay, go ahead.
We would concede that Detective Copsall and Detective Lowen are not testifying against us in court this morning.
They're still under defense subpoena.
I
We are
asked,
not-
I asked Mr. Henderson. if you guys recall.
Oh, okay. I'm gonna stop this. Basically, the detectives were in the courtroom and they kicked them out because I think they thought they were going to testify, but then they decided not to have them testify any further. So, so he did all of that. He got what he wanted. He wanted another deposition. He got what he wanted. And then we're going to jump into a little bit of the prosecution's questioning of the witness moving forward. And then we're going to stop it again because the defense also has a problem with the line of questioning that's going forward at this point. After that, we'll jump into his arguments after lunch. Not really going to cover the witness that much because, of course, she had a lot of things to say. But so far, the defense just wasted over an hour of time arguing that she had new testimony when she really didn't have any new testimony. Everything that he asked her about is literally things that she has already testified about. The narcissistic traits, he read that out of the transcript. The anxiety disorder, the adjustment disorder. He read all of that out of the transcript, but then asked her follow-up questions on the exact same thing that she already talked about in the deposition. So I'm just waiting for the judge to kick the detectives out of the courtroom, and then they're going to start bringing the jury back in and questioning the witness again, and then they're going to kick the jury back out because the defense has thrown hissy fits at this point. He cannot lose. Okay, so let me have Bossy V bring us in. And honestly, I can't help but think that these are stalling tactics by the defense. They have already objected to the statement that the psychiatrist, the doctor, doesn't really know whether what was I going to say? The psychiatrist doesn't know if she has PTSD because she didn't get enough information. And I guess she didn't ask the follow-up questions, or maybe she did ask questions and then Sarah didn't explain them at the time she asked the question. So then she did her own catch-all question. And Sarah didn't add any information about her being constantly scared of him, which if that's your argument and you know that's going to be your argument since you hired this defense team, and I would presume you were trying to convince your other defense teams to also make this argument, you probably would have said, oh yeah, I have intrusive thoughts. You already did your interviews with your previous psychologist. So why would you not give her the same information that you gave your own expert? So let's jump back into it. We got, let me see here, mute. And then we're going to.
And we're going to continue the state's rebuttal case this morning. Again, if you could please just raise your hands to confirm that you complied with the court's instructions.
We're in the
break.
rebuttal part of
all
the
hands have been
case.
raised. Mr. J, you may continue your inquiry, sir.
State would move to strike the last response as non-responsive.
Approach.
I didn't hear the last response, so I don't know Which one? What they talked about before? I'm sorry, y'all. I cut into it and I don't want to like jump back because I don't want to get us too far back into the rewind of the case. So at least, like I said, at least Sarah Boone's defense attorney is going to bat for her. Is it good going to bat for her? Is he doing a good job? That itself is questionable. I don't think he's really doing a good job. I think he's trying to delay the trial at this point because he probably does not believe that he's on good footing. But I don't think the state is either.
Irrespective of whether anybody has an opinion about whether Ms. Boone was suffering from PTSD or BSS, irrespective of that, based on your evaluation of Ms. Boone and what she relayed to you about the facts of the case, does PTSD or BSS have any relation?
Objection, that's an asked and answered.
Overruled.
No.
Got to remind the jury.
And what particular part of her statements about the incident is that?
The whole part where she's describing the part about playing hide and seek and that they were having a good time, they were laughing when he got in the suitcase, when she found him, they were enjoying themselves, she zipped him up, they were still laughing, having a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent, there was an imminent risk of harm that she needed to protect herself.
And then here we go with the defense objecting. Here we go with the defense objecting again. And my girl is rolling her eyes. She's so mad. She is so freaking mad right now because what do you mean objection? And so he's going to go into this, talk about, she's giving her opinion. Yes, because she's an expert. She's an expert. She's saying that at that time, she was not in that imminent feared state of, okay, this is building up. When Sarah Boone told us she got into her state is after she video recorded him and was taunting him, and then she turned off the video, and then all of a sudden his tone changed and she knew what was about to happen. So yeah, no, you can't start something and then throw the rock at the glass house and then hide the hand, right? And so this doctor is saying at the time that she started abusing the suitcase, she was not in fear. She got mad and decided to attack him because she thought his tone changed, which we don't even know if his tone actually changed because she cut the video off. And then she told us she doesn't even know what happened before the 9 minutes before she turned the video on. And the tone we heard from George was him pretty scared, right? He was pretty scared, didn't really know what was happening to him, and he could not breathe and wanted to be let out. So I don't know if she's in a good position to make the argument that she's trying to make. Let me see if I can jump to where we are. Okay. I think they kicked the jury back out.
Yes, irrespective of that, based on your evaluation of Ms. Boone, what she relayed to you about the facts of this case, does PTSD or BSS have any relation? Mr. Owens' objection, asked and answered. The court overruled. The witness, no. Question, and what particular part of her statements about the incident is that? Answer, the whole part when she's describing the part about playing hide and seek, they were having a good time, they were laughing. When he got into the suitcase, when she found him, they were enjoying themselves. She zipped him, they were still laughing, having a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent risk of harm.
Any other argument, Mr. Rollins?
That invades the province of the jury. That's a decision. Whether or not she had imminent risk of harm or perceived an imminent threat is a question for the jury. This expert can express opinions on science, on medicine, but not on the ultimate issue of fact, and explain to the jury that this defense.
She was explaining her opinion.
You rely on me as an expert, and I'm going to make the decision for you, ladies and gentlemen of the jury, by telling you that under the facts expressed to me by Sarah Boone, she was not perceiving an imminent threat at the time.
Response.
It's not an objectionable opinion. It's not an opinion on the ultimate issue. It's an opinion on the applicability of a particular set of evidence that testimony offered, called battered spouse syndrome, to kind of help explain a portion of the justifiable use of deadly force or non-deadly force instructions. She's not up there saying Ms. Boone was unjustified in doing what she did. She's not saying that justifiable use of force doesn't apply. What she is saying is, in her opinion, based on the facts that she relies on, given by the defendant herself just a couple of weeks ago, that this particular set of testimony and evidence that has been offered through their expert, Dr. Harper,
does not support.
This is no different than one expert coming in and saying, well, yeah, you can know that the defendant was sane at the time, despite his mental illness, because he ran from the police, he hid, he concealed evidence, so on and so forth. And therefore, because of those facts, insanity doesn't apply. And a defense expert may come in and say,
good job, prosecution.
Insanity does apply because my client, after stabbing her mother to death, called 911, was speaking unintelligibly and singing, and greeted the officers at the door with a pair of knives and wouldn't drop the knives and was incoherent for 12 hours after the offense. Therefore, based on those facts,
is he describing that Carly case?
It's not becoming a lawyer. It's not becoming the juror. It is explaining a particular type of expert testimony. And it just happens to disagree with Dr. Harper's. And Dr. Harper came in and said that BSS does apply and that she was in constant fear. And the reason she's in constant fear is because of all the past episodes and whatnot. It's permissible testimony.
Any other argument, Mr. Owens?
That's totally wrong.
You said it's totally wrong.
Dr. Harper came in and said BSS does apply. That's true. But
yes.
he got through saying and trying to get the witness to say BSS, it's not to be regarded. Post-traumatic stress is not to be regarded. It doesn't even come into play. Post-traumatic stress disorder, bad stress syndrome does not even come into play because at the time she was facing, according to this witness, no imminent risk of harm. Therefore, you can discount everything you hear, ladies and gentlemen of the jury, about battered spouse syndrome.
How does that have anything to do with whether or not it's an improper legal opinion under 90.7
It is. It's the ultimate issue of fact in this case because self-defense has been alleged by the defense. And the issue for this jury is whether or not Sarah Boone had the right to defend herself with force, deadly force or non-deadly force, based on her beliefs and impressions at the time, whether they were reasonable under the jury instructions, under the special jury instructions that are going to be applied for battered spouse syndrome, under the jury instructions, under justifiable use of deadly force, whether her perceptions about the threat was imminent and whether it was appropriate or reasonable to act the way she did. This expert is trying to say that she was not facing imminent risk of harm at the time.
Not what you said.
Thank you both for your arguments. Court is going to overrule your objection, find that it is not an ultimate issue of fact as addressed by 90.703. The court specifically relies on Dinkins versus State 976, Southern 2nd, 6.
Crazy part of that whole argument of she's not even talking about the portion that his client got up there on the stand and said when she started to have the fear. Where she said she started to have the fear was after she did the first recording and beat him with a bat. That's when she started to have fear. So he's making this whole horse and pony show trying to distract everyone and confuse everyone. I feel like that's all he's trying to do is confuse the issues. And the judge is doing a good job at catching him in his lies, catching him in his inconsistencies. No, that is not what we're talking about, sir. No, that is not what we're talking about, sir. And getting everybody to kind of move on and get on with the day. The prosecution continues to question her. She gets out more information about the facts surrounding the incident was not supported by battered spouse syndrome. You saw him eating some ice cream and you decided you was going to beat him upside the head with a baseball bat. Maybe that's you starting some mess, right? That might not be battered spouse syndrome. That might not be it. And that's what the witness is testifying to, just like their witness testified that it does apply, right? She was in fear because she knew of the tone, right, that he was using. Let's forget the fact that she got him locked in a suitcase and he's trying to get out and she's not letting him out. His tone is what scared her, although she's the one that's falsely imprisoning him and all of the above, right? She's committing felonies against him, but all of a sudden he's the problem because now he's getting upset. He asked nicely, and according to her, now he's getting upset. If you guys watched the trial today, there was a couple of videos that was played that Sarah tried to point out that he was the aggressor the entire time. These are videos that she's recording and she's the aggressor in the videos. And then we'll get into the videos in just a moment. Let me go ahead and jump to defense trying to argue again over this transcript. One thing about this guy is he is not going to give up. Like when he wants to argue something, he is absolutely going to push for it. He's not going to give up on it. And I don't know what his line of thought is. I think he's going to lunch and Sarah's like, you better argue this, you better argue that. And then he just has to do it. Otherwise, she's going to try to argue ineffective assistance of counsel. Because remember, she's been very satisfied with the job that her attorney has been doing so far. So like I said, the prosecution finished up their questioning and then defense started some of their questioning. He basically started trying to ask her, you talked about psychologists and how they don't have medical training, so they don't know anything about medicine, right? I'm like, are you trying to fight on the stand? Like, why are we starting off like that? Anyways, they don't finish their questioning. They go to lunch and the defense comes back and he wants to argue this transcript issue again. We didn't just spend over an hour arguing this before lunch, and then you tried to argue something else that was BS, talking about her giving her opinion about what the facts are. I don't agree with that. And then now we're coming back after lunch and you want to go over the transcript again. So let's go ahead and jump into that part of it, and then we'll jump into the discussion of the videos.
0 at pinpoint 661. In that case, the psychologist testifies. In the instant case, in Dinkins, the psychologist's opinions were not legal conclusions. The psychologist did not.
Oh, my bad. I thought I skipped ahead, but I didn't. Okay, here we go.
Yes.
No, sir.
Yes, sir.
I'll make another motion. Judge, I've had a chance to read this
Another
transcript,
motion.
and I'd like to draw your attention to a few pages.
Which transcript are we referring to, sir?
The October 4th, 2024 deposition of Dr. Tanya Werner.
Okay.
No,
Yes,
I'm
sir. I have
blocking
it in
the
front of
judge. I just realized it.
Yes, sir.
I'm referring to page 38 at the very bottom, line 21. Okay. Answer, I need to go through my notes and think about it and process it. But I had other depositions, as you were aware yesterday, so I had to prepare for those and go through that. So I had not had time to process through all of my notes.
We already read this.
Page 39. Line 2, well, doctor, I'm not trying to inconvenience you. You know, the judge said.
We literally already read
this.
this.
Line 5, she answered, okay. Question at 6, but I don't anticipate your testimony would be until later, you know? Maybe we could discontinue your deposition and then reset it when you've got time to review.
He's always trying to get a
Because obviously I'm not going
continuance.
to want to take your deposition.
Court
and
already
have
said
other
no
opinions that are not
continuances.
going to be covered. And at 13, Mr. J says, what is your position? And at 14, Mr. J, conducting discovery after the jury trial starts is completely unacceptable to me, so that's my position. If she needs to issue a supplemental report, or if there becomes a need for a second deposition, then we can address that. But it would be my position that we need to get this done because the state doesn't have any appellate rights once the jury is sworn in jeopardy of attaches. Line 23, Mr. Owens, well, you obviously understand my position. I'd like to finish the deposition today as well. But if she is holding out, if she may have other opinions and other diagnosis.
Let it go.
After she has had more time to think, review the paperwork, then obviously that creates an issue. The witness on line 4, page 40. But if that happens, I can bring that forward, and then you can add to your deposition at that point. If my opinions change after having reviewed further. Line 8, Mr. Owens. Mr. J. Line 9, Mr. J. I think you need to plow ahead. This is our time later. The court reporter is prepared to give us a transcript by the end of the weekend, and if something needs to be amended, then she can A, issue a report, and then B.
Off topic, y'all. His glasses are not even behind his ears, and now that's starting to bother me. It's just like floating on his head. I know it's off topic, but sorry.
If you need to take a deposition, an abbreviated deposition,
Look
on
at
a
his
limited subject that
glasses.
she is not prepared to testify about on today, then we can do that. But the notion of halting a deposition today that is set for 3 hours and then doing a 3-hour deposition during trial, especially after jeopardy is attached, is not what the state will do. Line 23, page 40, Mr. Owens. I'm not suggesting that, Mr. J. I'm suggesting that we just said at the very beginning. I'm suggesting what you just said at the very beginning, which is let's finish. But if she has some supplement, then I would want to take a brief second deposition as it relates to any new diagnoses or opinions. Then Mr. J goes, I think he gets confused about an issue relating to a diagnosis of an adjustment disorder or anxiety disorder. So we get down to the bottom of page 41, line 22, Mr. J. Okay, so on this topic, if something new comes up, then we can address it. But if we have other topics to depose her on, then I would suggest we go on.
Hang it up,
Page 42,
guy.
line 1, Mr. Owens, I agree. I agree. And Dr. Werner, just let the state attorney know. I know that you may be, we are on short time. If you do review your notes over the weekend or whatnot and formulate any other opinions, just let the state attorney know and we'll address it. Line 7, the witness, absolutely.
She hasn't changed her opinion, though. What
That was
now?
our understanding. I've been ambushed by a new opinion that I was not made aware of by any kind of report. I was not notified by Dr. Werner. I was not notified by the state attorney, William J. I first heard about the opinion when she testified to it, and I objected to it, relating to imminent threat, the ultimate issue of fact. I moved for total dismissal for prosecutorial misconduct.
Denied. And here's the other reason it's denied. Page 38 of the deposition, specifically that you made reference to, starts at page.
I missed that earlier. He moved for a total dismissal of the trial, or did I hear that wrong? The court is so annoyed with him. The fact that he just said denied and your other motion is denied. Your entire motion is denied, dude. What the heck are you talking about? We literally read that at the beginning of the trial, or not the beginning, in the beginning when he brought this issue up to begin with. And he said, I moved for a full dismissal. because I was ambushed. I want to tell y'all something about being a practicing lawyer. I do practice in family law, so it's not as intense. We don't really do discovery as much. We can, but we don't really do it as much. We don't do a lot of depositions because depositions cost a lot of money, and we're not trying to use up all of our clients' money in trying to figure out what the other person is going to say. Generally, when you're married, you have a pretty good idea of what your spouse is going to say, or if you have a child with someone, you have a pretty good idea of what they're going to say. So your client is able to inform you of what their position is prior to us getting into the case. So when he's talking about, oh, they ambushed me, I didn't know what to do, handle it on cross. If you think that she said something inconsistent, you handle it on cross with a prior inconsistent statement. I believe the defense made that argument during their case in chief. Either I think it was yesterday. They made that same argument that he can ask if he thinks it's an inconsistent statement. He can follow up on it on cross. Follow up on it on cross. And guess what, guy? You had an opportunity to follow up on cross, and you didn't do it. You still didn't do it. You made all of this fuss. We've been 2-3 hours in of you making all of this fuss. You spent the whole lunch stewing over this to just read the same part of the transcript again, and you still lost. You still lost. So wait, let me try to skip back a little bit. Where am I at right now? Let's get to him standing up. Okay. So I think he said he wants a full dismissal. Y'all correct me if I'm wrong about this full dismissal thing.
A diagnosis of an adjustment disorder or anxiety disorder. So we get down to the bottom of page 41, line 22, Mr. J. Okay, so on this topic, if something new comes up, then we can address it. But if we have other topics to depose her on, then I would suggest we go on. And then page 42, line 1, Mr. Owens, I agree. And Dr. Werner, just let the state attorney know.
Yes,
I know that you may be.
I just want to hear what he wanted to dismiss, if it's a full dismissal of the whole
If you review your
trial.
notes over the weekend or whatnot, and formulate any other opinions, just let the state attorney know and we'll address it. Line 7, the witness, absolutely.
Try again.
That was our understanding. I've been ambushed by a new opinion that I was not made aware of by any kind of report. I was not notified by Dr. Werner. I was not notified by the state attorney, William J. I first heard about the opinion when she testified to it, and I objected to it, relating to imminent threat, the ultimate issue of fact. I moved for total dismissal for prosecutorial misconduct.
Denied. And here's the other reason it's denied. Page 38 of the deposition, specifically that you made reference to.
I don't know why that's so funny, the way he said denied. No, sir. What are you talking about? And so he wanted prosecutorial. Why can't I say it? I literally have content about prosecutorial. The prosecutor's misconduct is what I'm trying to say. I have content prepared for that because there are actually cases that have been appealed because of actual prosecutor's misconduct. The court has already ruled on it. Whatever the state did was inadvertent. She told him that the testimony didn't change. And to me, the testimony really didn't change. Let's see what the judge has to say regarding the transcript. And then I'm going to go ahead and jump to the videos. I'm not going to play any of the videos that they played. I'm just going to kind of give my opinion on it. And then we're going to jump right into the chat on these issues. So let's get this going for the court's opinion as to why they're denied. Boy, sit down. That's how I feel like he wanted to say, boy, sit down.
It starts at page 21, line 21. The question preceding that is important. Question 14. So from my understanding, when you just said was, yeah, I agree with general anxiety disorder that she had been diagnosed with. Answer, no. I said it would be generalized anxiety disorder versus adjustment disorder, and that I hadn't had time to fully formulate that opinion out. This entire conversation pertains to those two issues. Anxiety disorder and adjustment disorder. Has nothing to do with PTSD, nothing to do with battered spouse.
Snappy.
Judge, we go on, and I see what she's doing. And she's saying, hey, I got jammed up. I had a deposition yesterday. I didn't really have time between the evaluation and the deposition 2 days later. She had a deposition in between to really think about it, really review my notes. So as a catch-all, I said on page 40, if you have other opinions or other diagnoses after she has more time to think and review the paperwork, then obviously that creates an issue. So yes, that was initially what she was talking about specifically, but I realized what she was saying was she was going to have to reflect on a lot of these opinions. So
that's respectfully, sir, that's not what it says. That's specifically in line with the anxiety disorder versus adjustment disorder. That was the entire topic that was being conversed with. Now, later in the deposition, there are references, as I believe that I identified previously. Give me a moment.
Judge said we are not going to do that. We are not going to do that. That's not what it says. You're
on page 59, line 22. Question is asked. Okay. And do you intend on expressing any other opinions other than what we've spoken about here today? Line 25, no. I will answer whatever questions I'm, moving to page 60, line 1, asked.
So if you didn't ask it before, that's your
Page
problem,
60,
not hers.
Line 11. Well, let me just start with 2 because it gives it more context. Question. Well, I'm asking now. I mean, you're the expert. I'm not. You're the one that's evaluated her. You're the one that's given her the test. I don't know the field like you do. You know the field. I understand you've said, hey, I want to think some more about, hey, I want to think about this some more. I want to review my notes some more to see if, but in terms of right now, without any further reflection, without any further answer, yes, sir. Question, reading of the notes, any other opinions that you think you could express in any form or fashion with all this experience, almost 1,000 jury trial or 1,000 trials you've testified as an expert. Anything else that comes to mind that may be an opinion that you might express in Sarah Boone's case? Answer. Anything else that I'm asked with regard to her diagnosis come into play with regard to her case, I guess? Question. What other opinions do you believe you're qualified to express as it relates to Sarah Boone and the facts and circumstances relating to this case? Anything with regard to her diagnosis, I guess? 61. Of those 4 things we mentioned, line 2, correct.
And Judge, the 4 things were mentioned were related to the anxiety disorder, the narcissism, the battered spouse, the alcohol use disorder, in pages 58 and 59. But the overall thrust of that was any other opinions that were expressed. That was in good faith what we were doing. I would have, like I said before, I would have never taken her deposition. Once she said I hadn't finished my analysis and I may need additional information, just like he said the other day, Dr. Harper, if you get those additional medical records, Mr. Owens, about George Torres, and give it to Dr. Harper, then I'm going to want to take her deposition again. The same rules apply. Why would I take her deposition when she hasn't finished?
Because the court ordered you to take her deposition because there were concerns about being able to have all of this done prior to trial. And you had concerns about what she was going to testify to.
Yeah.
And the court set a scheduling order as to when, how, where, and the deadlines for those depositions to be conducted.
Mad now.
That prosecutor should have let me know if he was going to ambush me at trial. I should have known beforehand.
Nobody
about the
ambushed
opinion that
you.
Dr. Werner was going to express, especially related to battered spouse, post-traumatic stress, and whether or not it was an imminent threat at the time of this event.
And the courts addressed that. Court does exactly what was required by binding precedent by the 6th District Court of Appeal and held a Richardson hearing, analyzed the 3 factors as required by Florida law with regard to those, and gave you the opportunity as a cure. And with regard to your request to strike or dismiss the case due to prosecutorial conduct, the case law by the 3rd District Court of Appeal filed April 10, 2024, State of Florida versus Denninghoff, Denninghoff, and I can provide you a citation momentarily, states that dismissal is an extreme sanction to be used with caution and only when a lesser sanction wouldn't achieve the desired result. Specifically, dismissal of an information or indictment is an action of such magnitude that resort to such sanction should only be had when no viable alternative exists. There were multiple viable alternatives, including but not limited to my request in inquiry of whether or not you wanted that struck and the instruction to strike that opinion, which you demurred and said, no, I want it for cross-examination. And I gave you the opportunity twice to depose her here in open court, which I oversaw with regard to any opinion that she had based on the proffer or any other opinion that she would be offering today. For those reasons, the court is not going to exercise its discretion and strike due to the extreme nature of striking a criminal charge and for the adequate remedy that has been provided to you.
Yep.
Is there anything else, sir, we need to address?
May I supplement the record?
Yes, sir.
The state's like, they didn't throw me under the bus.
40 or 41 or 42. Mr. Owens took a direct examination of this deponent for 68 pages, and then it was turned over to myself for cross-examination during the deposition. Beginning on page 75, I asked the deponent, what did the defendant say about the murder? What she said on page 78 was that, starting at line 13, and she said there was a suitcase and some clothes that had gotten out to donate, and they were trying to get that together. It was on the floor in the living room. And that, as she was coming down the stairs, she saw him kind of slipping into the suitcase as a hiding place. As she said, I saw him in the suitcase and I zipped him up and we were laughing. She said then he said he couldn't breathe. And I remembered feeling I couldn't breathe when he was choking me or sodomizing. And I was angry and I shook the suitcase. I lost control of the suitcase and it flipped. And she goes on and on about what happened. Defense counsel was there. He heard this testimony that there was no imminent danger presented at the time that she began getting angry, shaking the suitcase, hitting him with a bat, so on and so forth. And he didn't ask her that question after she had specifically instructed him, if you need an opinion of mine, you've got to ask me the question.
Right.
It's unfair to experts to be thrown with this catch-all provision of, please tell me any opinion about this case that you may think is relevant. Well, what the doctor may think is relevant is different than perhaps what counsel thinks is relevant. So it's really an unfair criticism of the state and probably more likely self-reflective that this deposition, this opportunity to ask about this obvious issue did not occur. So that is what I would like to supplement the record with. The deposition was substantially longer than page 41 or 42, where it's acting like it's concluding and is there anything else? The state would just submit I understand very well what my ethical duties are.
Good job.
I do not have any ethical duty to provide him an unrecorded statement that is not inconsistent with prior testimony. This doctor did not give me any unrecorded statements inconsistent with her testimony.
Yeah.
Thank you.
Thank you.
I'd like to add on page 79 that Dr. Warner claims that Sarah
The
said.
judge is so over this dude. He keeps talking. He's like, what the hell? More? Is there more that you have to say, sir? Like, why? Just zip it and finish your case. You still have to cross-examine this lady. And you're spending all your breath, all your brain power, all your brain cells, it seems like, to make this argument that makes absolutely no sense. I can respect the prosecutor saying, sounds like he's projecting because he didn't ask the right questions. I completely agree with the prosecutor on that. Defense did not ask the right questions during deposition because he probably he did jump into this case, 45 days before a trial, probably didn't really know what was going on. And he's trying to do all of this discovery. And in this case, has been going on for almost 5 years. So now you're trying to blame it on the expert and try to get rid of her so that you don't have to defend your client. I think it's improper. I think the prosecutor did a good job calling him out. We got a little bit more of the defense trying to get around put the buggy before the horse. And then, like I said, we'll jump into the next part of things.
That he put his 2 fingers out and I hit them with a bat. So they were ruling completeness. But for him to say that that's not standard operating procedure when you're taking a deposition of an expert.
Mr. Owens, I've ruled, sir. I understand. I understand your position. However, the questions that were specifically asked, which gave rise to this, specifically pertain to opinions of PTSD. I'm not going to rehash any and all of those things. The record speaks for itself. The court has ruled. Your motion for dismissal of the charges is denied. For the record, the citation that the court relied upon with regard to Denninghoff is located at 388 Southern 3rd 10055, located at pinpoint 1057, Florida, 3rd District Court of Appeal, April 10th, 2024. With that, are we ready to bring back in our panel?
No, sir.
Okay.
Judge, I've got Earhart's Florida Evidence 2023 edition, volume 1. Charles
let me tell you how you're going to rule on this, sir. I'm going to allow you, as I said up here at sidebar, to go into the facts that she relied upon and what it is that she utilized. I'm going to allow you, sir, as I said up here at the bench before the lunch hour, to go into those opinions that she didn't offer here today. And on rebuttal, Mr. J, I'm not going to allow you to stand up and say, may I voir dire? That wasn't one of your opinions today. You can address all of that and redirect. Is that
exactly? Yes. Handle it in court.
Judge, let me just review to see if, because I had several.
What you had inquired of me, Mr. Owens, up here was that you wanted to go into these other facts, medical records, text messages, statements. And you said, if I can't do it now because he's going to object, I'm going to call her and assert rebuttal. And the problem, as the state pointed out, is that you can't use her as a conduit to admissible evidence on direct examination. And that if you want to do it, you got to do it now. Yep. And your argument was it goes to her bias, it goes to her credibility, and that you're permitted wide discretion on cross-examination. I agree with you. I agreed with you before the lunch hour. My ruling hasn't changed.
Handle it on the court. That's what the judge is saying.
I'm going to absolutely allow you to go into those things.
I appreciate that, Judge.
But
I wanted to readdress was
you want to sit here and argue with the judge instead of handling it on the court, like the basketball court. You know, you got to handle it on the court. You got problems, deal with it on the court. So the judge finally gets rid of him. He's not going through all of that. I can't remember if that was the absolute most aggressive part of the judge handling him. Let's just watch the rest of it because it's only like 1 or 2 more minutes, and then we'll jump into the next. I know I keep saying that, y'all, but I feel like I'm missing this part where the judge kind of got a little bit more aggressive with him, and I want y'all to see it too.
I'm taking care of it, Counselor. Give me a moment.
I want to say, but I could be wrong. Maybe that was the aggressive part.
Yes, sir.
Judge, I'm referring to Earhart's treatise, section 9.73, opinion on the ultimate
Let
issue.
it go.
I'm on page 933. Testimony in the form of an opinion or inference otherwise admissible is not objectable because it includes an ultimate
The way
issue
he grabbed his book, you know he about to go off.
73.1, it talks about
He's flipping them pages hard.
opinion testimony is not inadmissible solely because it includes an ultimate issue to be decided by the trier of fact. The provision is equally applicable to expert and lay witnesses. The jury has the power to accept or reject the testimony of expert or lay witnesses.
You about to eat him up. You about to blame him.
Witness expresses an opinion to an ultimate issue does not compel the jury to find the facts to be true. The jury will be given the opinion. The jury will give the opinion as much weight as it feels.
You have got to feel dumb.
Then it goes on.
How do you not feel dumb?
The abolition of the rule against opinions on the ultimate issues does not mean that all other opinions are admissible. Witnesses will be prevented from expressing their conclusions when the opinion only tells the jury how to decide the case.
Sarah even seems bored with this.
Witnesses will be prevented from expressing their conclusions when the opinion only tells the jury how to decide the case and does not help the jury to determine what occurred.
That's not what
For example,
happened,
witness
though.
cannot express his or her opinion as to the guilt or innocence of a criminal defendant.
She didn't do that, though. She just said it didn't apply to that incident. Which is her opinion, just like yours had an opinion.
703.1 still. When a witness is asked to express an opinion that applies a legal standard to a set of facts, which
He's not even listening at this point. He's about to flame him.
Is generally inadmissible. The danger is that the witness will apply a standard or definition which is different from that defined by the applicable law. The application of erroneous legal standard results in the opinion testimony being misleading and not helpful to the jury. For example, an expert cannot opine whether a nursing home was negligent in its care of the decedent.
It's exactly what we spoke about at counsel's table.
No, Judge, but if you go on, it says an expert may not be permitted that a truck driver drove in a grossly negligent manner, whether the sheriff's conduct was unconstitutional, whether certain waters are navigable, whether the defendant's action constituted misapplication or concealment of funds, or the legal obligations of the parties to a contract, whether the testimony of the expert is a permissible
lawyering they've done this whole trial.
The impermissible application of a legal standard or definition to a set of facts is sometimes a fine distinction involving a large measure of discretion with a trial judge. For example, the admission of expert testimony.
The trial judge has discretion, yes.
However, the witness expresses an opinion about the intent of the accused. The opinion, this is one of the important sections. However, if the witness expresses an opinion about the intent of the accused, which Dr. Werner did, the opinion has not been permitted. The distinction drawn by the courts as to when this type of opinion testimony is admissible are often not clear. Section 90.73 does not permit a witness to testify to legal conclusions.
Her mental state wasn't where she's saying it was.
This expert testimony regarding substantive legal principles may not be helpful to the jury and may create confusion if an expert testifies in a manner that is different or even in conflict with the testimony of an opposing expert.
But the citations, respectfully, Counselor,
Respectfully,
Counselor, the citations that you're referring to are not at issue.
Let me finish as well.
Failure to permit arresting officer to testify that a quantity of cocaine possessed by appellant indicated that he possessed with intent to sell, which is a specific element of the charge in that case. Gamble. Officer's expert testimony with the amount of drugs found in defendant's possession was inconsistent with personal use and therefore intended for sale was inadmissible. 644 2nd 1376 by 4 Gamble and Fluellen 703 2nd 511. The Dinkin case that I read says this is acceptable. If a psychologist or psychiatrist can testify that someone is not mentally defective or was mentally defective, that's on all fours with based on what the defendant has said to this expert. She was not in imminent fear. Now, I don't remember exactly what was said, but it was along those lines. Based on looking all those things, the totality of the circumstances of what, in my evaluation, on or about October 2, that the defendant had said to me as the expert, it's not imminent fear. That opinion is not inadmissible per the case law under Dinkins.
Opinion based on what she was told.
If
you're just going to be reading from the treatise, I've already read it.
Okay, well, I just want to make mention because it's talking about does not prevent a witness to testify about legal conclusions or express opinions on questions of substantive law. And I was about to finish this section.
Let me finish.
This testimony, I'm on page 947. This testimony may also interfere with the function of the trial judge to determine the applicable law and to instruct the jury thereon. As we know, we're going to do battle over the jury instruction on justifiable use of deadly and non-deadly force. The testimony from Dr. Werner, and I wrote it down. She said based on what Sarah Boone told her, she was not facing imminent risk of harm. That invades the province and function of the trial judge to determine the applicable law and to instruct the jury otherwise, which we haven't even done yet. You haven't made findings of law about which instructions apply. That's what she did, Judge.
Your objection's been made for the record. The court previously ruled on this matter. I appreciate the additional argument, but the court's reliance on Dinkins remains. Just because 9703 speaks for itself. So your objection is overruled as to that issue. Anything else we need to address, Mr. Owens, before we bring back in our panel?
No.
State?
Nothing. Thank you, Judge.
Okay, let's bring back in our panel.
Over it. He's so over it. Like what? Why? How did we end up here? Why did the judge have to explain that to you 57 times? I do think a lot of it has to do with Sarah pushing him to make sure he is getting these things across to the judge. But at this point, it's making him look dumb. One other thing that I noticed, which I didn't notice in the beginning, is that Owens does not actually normally practice in this county. He practices in a different county. So he may not be familiar with this judge and the judge may not be familiar with him. And maybe this BS works in his counties, but it's not working with this judge. He is not having it. Kranig is not having it at all. But for him to tell the judge, let me finish. No. Judge said respectfully, that does not apply. He is for sure over him, absolutely over him. So yeah, the jury comes back in and Owens gets to finish his cross. But maybe if he would have paid more attention to doing his cross rather than trying to get the case dismissed for the prosecutor having misconduct, that the judge already ruled was not on purpose. It was inadvertent. The witness told him that her testimony hasn't changed, which again, I will stand by. I do not think her testimony changed from the deposition. he already ruled on that, and then you're bringing it back up. Basically, you're trying to call the judge dumb at that point, and that he doesn't know what he's doing, and that it needs to be dismissed. I don't agree with it. The judge didn't agree with it, and he got served on the stand. Respectfully, sir, shut up. That's probably what he really wanted to say. Respectfully, shut up, Owens. Shut up. It does not apply. She gave an opinion based on the facts that she gave her. She was not in imminent fear. And she even told us on the stand, Sarah even told us on the stand that she was not in imminent fear because she felt comfortable enough to talk to him while he was in the suitcase. And then we see how she talks to him on video later on in the trial. Again, we're not going to cover it on this live stream because your girl is not about to be here all night, okay? Because it's long, it's boring. I didn't like the videos. I stopped paying attention, so I'm not going to have y'all all confused on my live stream. So defense goes on and continues to question her. What I didn't like about this witness, then we're talking about Dr. Werner. She didn't really review like the police interview. She didn't review the actual suitcase video. I think that would have helped her in her opinion. They talked about the whole psychologist thing. She did diagnose Sarah with alcohol abuse disorder, which is similar to what Dr. Harper diagnosed her with yesterday. And then she also did diagnose her with the adjustment disorder, which I believe that, no, she did not. So the psychiatrist today, Dr. Werner, diagnosed her with the adjustment disorder. Dr. Harper from yesterday did not diagnose her with the adjustment disorder. She stated that she had no generalized anxiety, but Dr. Harper did testify that she believes that she had generalized anxiety. And then also Dr. Harper testified to her having PTSD. But we have to remember that Dr. Harper talked to Sarah 9 times. I'm assuming it would have been longer than 2.5 hours, which the psychiatrist only had 2.5 hours with her. She did indicate that she believes that they had a volatile relationship. I think this was the point where the defense was supposed to go in and try to get the expert to admit that she believes that Sarah had battered spouse syndrome, which she did during the court-ordered, or not court-ordered, but the deposition that just happened in court a few hours before this arrived, before we got to this point. And he did not go into it. And I really think that if he would have focused his time on lunch, getting his cross-examination questions together where they just talked about he would have broad range to talk about a lot of things, a lot of leeway to ask certain questions, he did not take the opportunity to really nail that witness. And I really think he could have nailed that witness, being that she didn't review a lot of the material that she probably should have reviewed. And she also didn't spend as much time with Sarah as she probably could have spent. And I think this was a really weak part of the prosecution's case. And the defense did not seize the opportunity. Instead, he argued with the judge, making the judge mad instead of actually handling his business in court. On the court, we see the basketball players doing it. This guy was not ready to handle his BS on the court. She did indicate that they had a volatile relationship. The defense tried to get her to admit that George Torres was the aggressor in all of the incidents. He didn't even give her a specific incident of anything that she would know about. He just wanted her to generally say that George Torres was the aggressor when she's already told you she hasn't reviewed a lot of the video. So how would she even be able to make that opinion other than based on what Sarah says? And then she was able to throw in, which she did a really good job, that yes, they had a volatile relationship. Regarding the aggressor thing, she read the police report where Brian Boone, the ex-husband, actually said that Sarah is the initial aggressor on most occasions, or if not all occasions. I can't remember exactly what she said. And then the defense went down this rabbit hole of showing this witness these pictures of Sarah Boone with bruises, like the black eye and everything, and say, hey, does this look like it's caused from abuse? Does this look, or does these show injuries? I forgot which question he was actually asking, but he was just showing her all of these pictures with no context at all. We just know it's Sarah Boone and she's in these pictures. He doesn't ask, how did she get these injuries or anything like that. And I think the prosecution did a really good job when they came back on redirect to clean it up and saying, okay, you saw these pictures. is there any way that you can tell how these injuries occurred or who was the initial aggressor? And she said no to every single picture. So I think that the prosecution did a very good job in cleaning that up. And then he also added in the last statement that he got the witness to say is that having battered spouse syndrome does not justify every violent act. And that's the prosecutor's position, is that just because she may have battered spouse syndrome, what she did on this occasion is not justified in that, right? She's not having a reaction to all of the abuse. And also, you can't claim the self-defense when you're the one that's starting it. And honestly, after the videos that we get into, it looks like it was a situation of mutual abuse. I know a lot of people were saying that in the chat. And I know a lot of people think that's not a thing because there's always going to be a more dominant abuser. But after watching the videos, I do see more of a mutual abuse situation, which I will explain after we have Bossy B bring us in. Okay, so we are jumping into just kind of generally talking about the videos. We're not going to go through every single one. We're not going to talk about every single one. And before we have Bossy B bring us in, I was mentioning that it seems more of a situation of mutual abuse. The prosecution, I don't know. And if y'all can let me know in the chat how these videos even got admitted. They just moved them into evidence and then played them. I guess they might have been videos that the party stipulated to, but I don't remember watching them stipulate to those videos coming in. No one was on the stand. I don't know how they were put in, but there were a bunch of the police camera videos of the police coming to the house when Sarah Boone called them, also the 911 calls, and then some videos that it looks like Sarah recorded on her own on her phone. And when the police were arriving, well, first of all, when she would call the police, sounding completely calm. And I know everyone reacts to abuse differently, right? She sounded calm. It almost sounded to me like she was trying to set him up. And I'll get into why I think she tried to set him up on multiple occasions. Even this occasion, I feel like it was a setup, like I mentioned a little bit earlier on in the stream. So the police call, she was completely calm on most of the police calls. There was one where she was crying. I don't know if it was very genuine to me. I could be biased, but the crying phone call did not sound genuine to me. When the police were arriving at her house, she was running up to them saying like, yay, you're here. And like, she's like this super animated person, not as a person that will be in distress as someone just beat you up. And then one thing that they got in on those videos was him telling the police that she's hiding his birth certificate, his ID, and his social security card, which is one of the points that the state has tried to highlight as a form of abuse. She was controlling his documents that he would need in order to get a job. And she was talking about how George had just lost his job. So that would be a form of abuse. Like I said, she's acting all happy. She was telling one of the cops, oh, you guys should come over here and hang out sometime. Like, what? He's trying to do his job and you're trying to hang out with the police officer? I don't know why she said that. Same thing when she was at her husband's house. She called the police and said George was there. Mind you, a lot of these incidences happened after there was already a no contact order. George was not supposed to be there. She said in her testimony, oh, he kept coming back even though there was a no contact order. The defense wanted to get this no contact order entered, but what it sounded like to me from the no contact order and from the videos that they were able to show today is that Sarah was probably inviting George back to the house and then using it against him when they were no longer getting along, which is completely not fair. And that's why I'm saying we're probably looking at something where it's more of a mutual abuse situation. Why are you running up to the police, happy that they're there? Why are you asking? There was one video where she was like, baby, I love you, please don't take them. But there was a no contact order, so the police took them anyway. So there's all these situations where it doesn't really look like she's afraid and she's more trying to assert her dominance over him. Like, yeah, see, I have a no contact order against you. I'm going to call the police on you now that I'm not getting along with you. And then so the videos that she recorded on her phone, it was in the similar nature of the actual suitcase video of her actually taunting him, telling him what he's doing wrong, her using more an aggressive tone. Y'all can definitely watch it on the court channels that covered the full trial, but you can definitely hear the taunting in her tone, the more aggressive. And that's why I say maybe Sarah didn't start the hitting, but she probably definitely tried to provoke him with her words. And I believe it was her witness that said that Sarah's weapon are her words. And she had videos of her doing the same thing, of her basically trying to put George in his place. And a lot of the videos where she was talking at him, and I'm not saying talking to him, she was talking at him, is demonstrated that she had some type of control over him because he wasn't like really yelling back at her. There was one video where he did record her back, but it wasn't a situation where you think, okay, as soon as they put down the phone, he's slapping her. I am almost inclined to believe that she would hit him first and then he would try to defend himself, and then, you know, everything arises. And then when you are in an abusive relationship, which I think the prosecution is going down that road, is that Sarah was the abusive one and George was the one reacting. And we can kind of feel that in that suitcase video. Same thing with the other videos of her kind of questioning him and like getting aggressive with him. And he's like, okay, fine, I shouldn't have reacted that way, blah, blah, blah. And it's almost like she had been attacking him and now he started to retaliate against her. And now we have a full aggressive relationship. And of course, a lot of times, although it's changing, the dynamic is changing, but a lot of times people automatically assume, police would automatically assume that the man is the initial aggressor because they tend to be stronger. So I feel like she tried to set him up in the videos where she was having him come over with a no contact order. And then as soon as he wasn't doing what she wanted to do, now she's calling the police to come and get him. Same thing with the day of the incident, telling him to call his daughters while he was drunk, telling him to call his brother and then yelling that he choked you. It's almost like she was trying to escalate situations because she said he pulled her down the stairs 2 nights before or the night before or whatever it may have been. And so I feel like she was like, okay, well, you did this to me. Let me do something to you. For instance, putting him in the suitcase, starting to record it and being like, hey, yeah, you do this stuff to me. You do this stuff to me. Now I have control. I have the control now. I'm the big bad person. That's what I felt about the videos. Y'all can definitely let me know what you thought about the videos. I'm not playing them on my channel because, like I said, they were long. They didn't give us any context. There was no one on the witness stand. They didn't really explain them. We just kind of had to draw our own conclusions. And what I think that it showed is that Sarah is not so innocent, although she tried to play so innocent on the stand. But the thing about it is we cannot cross-examine George, right? He's not there. So we can't believe him. Let's see what videos that you see Sarah created herself. If she was the victim, she could have created more victimized videos, right? She didn't. She created videos where she was the aggressor, and she had that one video with George breaking the TV. So there is that, and we can only assume she's telling the truth about being stabbed in the leg, right? Because George is not here for us to ask him about it. We don't know if she stabbed herself, right? Anyways, I know it's been a long time coming. I normally do chats at the beginning of the live stream, and we are switching it up and doing something different today. So, but I did see that we hit our like goal. Our like goal was 58 likes. And I know there are some of y'all in this chat. Well, let me go ahead and bossy be us before we get into that. Okay, there we go. Our like goal for the stream was 50 likes. We're at 58 likes, and I know some of y'all have not hit the like button because there are 71 people watching live. So if you haven't, please do hit the like button. It does help out the channel, and we definitely appreciate it. Like I said, this is a new format for the people that have been riding with the BriHive for the longest time. We normally do chats in the beginning or throughout the live stream, but today we are switching it up so that we could get through the recap. And now we're going to talk about thoughts as I was talking. Basically, and as the prosecutor was talking, and as the attorneys were talking as well, and see what y'all have to think about what's going on with this case. It's very surprising to me that it's literally almost over. We're probably going to be hearing closing arguments sometime Friday, and the case should be over sometime early next week once the jury comes back with a verdict. They still haven't gone through jury directions yet, so that's probably going to take a while, and no one wanted to show up early, and they didn't tell the jury to come late. So it's just a mess. They're making the jury wait. Anyways, let's see what the chat has to say. Oh, I forgot to say, we hit the like goal, and I forgot to play the like goal animation. So if you are sensitive to loud noises, we do have a loud boom at the beginning of our like goal. So if you are sensitive to sounds, this is your time to turn off or not to turn off, to turn down your volume for the light goal thingy. Then 3, 2, 1. All right. Shout out to the BriHive for hitting the like goal. And we still got some time on the stream. So definitely shout out. And y'all just hit it even more. We're at 69 likes. We were just at 58. Shout out to y'all for real. All right. We got Uncivil Law. Kurt saying this was a very messed up day. It was a very messed up day, a very long day. Uncivil Law says uncivil broken. I think Owens is a little bit broken. I think he's trying to go so... Excuse me. I think he's trying to go so hard for his client. He doesn't realize he's making himself look dumb. We got Stargazer Kawaii saying she was an odd expert. She was. And the amount of ums that she had, I don't even feel like she was prepared for today. And the defense could have done a really good job, and they just decided not to. They just decided to focus on attacking the prosecutor instead of attacking her testimony, which I think they could have done a really good job on. They got 4 or 5 attorneys there. Why not have them writing up questions while you are while they're doing the direct examination? I think he could have completely ripped this expert apart if he would have focused on the right things. Corey Williams says, today was definitely interesting. I keep listening to different people talk about it. Well, welcome in. We love that. Stargazer Kawaii says, she seems oddly too happy to be testifying. She did smile at odd times, and she definitely did not keep her demeanor on the stand. She would roll her eyes. She would give like that little side eye. She was not nice to the defense at all and started getting like really stern with him. In a good way, though, I would say. But her demeanor in the rolling the eyes was a little bit too much. Stargazer Kawaii says the ums are really bad. The ums were horrible. They were unbearable. I'm glad, actually, that maybe the defense was annoyed with the so that's why he kept going. That's why he kept dismissing the jury and just talking to the judge directly. Zealous Foe says, a little behind and catching up. I agree with your thoughts that she did state the same things in her testimony as her deposition, but I thought the judge decided to err on the side of blocking an appeal. I think so. And he did specifically say, in an abundance of caution, he did allow for the depo to go forward. So I would agree with you on that, of trying to block the appeal. Pamela Oliver says, Judge K is done. Absolutely. He's so over this guy. And Pamela Oliver says, I object as a detrimental as it's detrimental to my case. It's not fair, Your Honor. What is your legal objection? Sue says, I caught some of this live. Apparently, it's because she withheld her opinion that she was obliged to mention, it seems, but she didn't. She literally did not. And Sue says, allegedly, LOL. I think he's full of it. Yes, exactly. He thinks that she didn't give the opinion that they read multiple times, but nobody said. She literally said she didn't form an opinion now, and she's literally saying she couldn't form that opinion now. She said that she couldn't form that opinion that day, and now she's saying she couldn't form it now. And the only difference, and I've said this on the stream multiple times, the only difference was that at that time she hadn't reviewed her notes, but at this time she had reviewed her notes and determined that she didn't have enough information to determine whether she had PTSD or not. And that could have been really easy questions to cross-examine on. In fact, he had the information now, and he still didn't cross-examine on it. So it's like maybe he had a set of questions that he was just not willing to change. Maybe that's what it was, because he didn't get to it on cross. Kimberly Agar says, stupid lawyer Owens. Cheryl Reed said, it seems to me that Owens is always trying to call prosecution out. Yeah. And it's projection. You didn't do what you were supposed to do. You wanted her to answer questions that you didn't even ask, and then expected her to read your mind to know that you would want to know that information once you guys got to trial, and then got mad that she didn't know what was in your mind. No, it don't work like that. Someone somewhere says he is literally objecting to her opinion, which she was asked for. Yep, that's what it was. He doesn't like her opinion. Zello Spoo says, for me, Owens was so hit and miss. When he managed to get things right, he did well, but he stuck out so much at key points today. It was hard to watch. He couldn't let it go. I had the same feeling about him not being able to let it go yesterday when he kept what was the point he kept trying to argue yesterday? Dang, I forgot what it was. There was some point he kept trying to, or was it 2 days ago? And he came back like 3 times on the same motion. I can't remember what it is off the top of my head. Hopefully I remember it later. And if y'all remember it, feel free to drop it in the chat. Destined to Be says to Zealous Boo, I agree. He was advocating for her, but he wasn't always on point. He wasn't advocating the right things. What he should have been advocating is the wrong word is doing well on cross-examination. That's what he should have been doing, but he was too busy trying to be like, this is not fair, this needs to be dismissed because I'm not prepared. That should have been his argument. Your Honor, I'm not prepared. I'm not prepared. I didn't prepare either way. I have a set of list of questions and I can't change them because this is what I'm sticking to. That's what I feel like it was. Zealous Boo says to Destined to Be, yeah, I don't like how he does it sometimes. So I have to keep reminding myself he is zealously advocating for Sarah Boone, but sometimes he doesn't seem as experienced as he actually is. And he said that he's been doing this for over 35 years. And I said that the other day, I want to know how long he's been practicing because he act like he don't know what he's doing. Like I honestly feel like I can beat him at this point, and I don't even do criminal law, and I'm a baby attorney. But no, I did go on his website today because I be nosy, and he's been licensed since 1986, and he worked for the prosecution's office. He's worked as a public defender, and he's had his own practice for over 20 years. Why couldn't he handle this case? Maybe because he came in 45 days before the start of trial, but that was his decision to do so. So, suck it. You volunteered for this. Destined to Be says he doesn't present himself like an experienced attorney. He's not acting like it, right? Especially throwing the hissy fit that he did and continuing to argue the same point. Dang, what was the one the other day that he kept trying to argue? I can't remember. Someone somewhere says, I was wondering who this attorney reminded me of. It is Daryl Brooks if he was actually an attorney. Yes, let me finish, Your Honor. He was like getting so feisty with the judge, man. Yeah, they should have just let Sarah do it at this point. Give Up says someone said he negotiate plea deals instead of going to trial after charging a lot of money. It was a negative review. Apparently, he doesn't actually know how to defend. And the thing about lawyering is a lot of cases do settle because you never really know which way the judge is going to go. And then when you're in these situations with a jury, you never really know which way the jury is going to go. So the question is, do you want to roll the dice? And people have said that about him before, of that he probably thought that he could get Sarah to agree to a plea deal and then he would be the hero and then maybe it will grow his firm. But what he didn't know, when he should have looked into, Sarah already got rid of 8 of you hoes. Like, she done got rid of 8 attorneys. You thought you were going to be different. Why? He also came in asking for a continuance and the court said no continuance. And when he's like, I don't know why we couldn't continue the depo. He was trying to delay the trial to give him some more time. I don't know why we couldn't continue the depo and the judge was like, because the court ordered it and that you can't continue it so that we can get it done on time because you wanted to depose her. The judge was not having it at that point. I don't know why we had to do it at that time, because you came in late. That's your problem. Stargazer Kawaii says she created the situation. She can't claim self-defense. I agree. I think the prosecutor is right on point with that argument. Zello Spoo says, the most frustrating part is that it was all for nothing as he then decides to question her himself on the topic he was objected to. Yeah, he didn't get to his point. He didn't impeach her. He didn't do a good job. Give Up says the poor judge, he has so much patience. He does. But you could definitely tell in his body movement that he was starting to get annoyed. Zello Spoo says he sunk himself on cross. I agree. Absolutely. Cheryl Reed says this seemed to be a waste of time. It was. He didn't get anywhere with it. He thought he was going to get the case dismissed, but really he just annoyed the judge and the jury and everyone else. Because the jury, remember, the jury wasn't in the room, but they're out there waiting and waiting and waiting. And they could be doing something way better than just waiting, right? Give Up, this judge. This judge is so over it. Yes, I agree. Granny F5 says like, share, and subscribe. Yes, thank you for the reminder. I appreciate that. Someone somewhere says her attorney looks like a bully. I mean, she is a witness and he is being very disrespectful. Sad sack of air he is. He was being rude, but she was handling him. I'm not mad at her. Give Up says, what a jerk. He's intimidating. I hope she stands her ground. And she did. We didn't watch it on the live stream, but you can definitely catch it on some of the court channels that cover the full live stream. Your girl got to go to bed though, because I go to work like a regular person and then I come on here and yap. So I cannot watch the full trial after I get off work. Stargazer Kawaii says she didn't deserve to be berated like this. I definitely agree. He didn't do a good job. That says, this was my question. How is it her fault that he doesn't know how to do a deposition? Yes. You're mad at the expert because you didn't ask the questions you needed to ask. How is that her fault again? Because you decided to come into the case late. How is that her fault? Ask the questions. And then you turned around and complained about her not answering your questions, and then turned around and did a cross-examination and didn't ask her any questions. And she didn't ask any questions that would help your case. And she actually said stuff during your court depo that would have helped your case. And you didn't use it. Stargazer Kawaii says, there's no ball to hide, but he is mad he can't see a ball that doesn't exist. Yeah, the judge is like, I disagree that there's any hiding of a ball. The judge is like, what the F? Like, what is going on here? Give Up says, there's a disorder for everything. Wow. What disorder does Owens have? That's what I was thinking, actually. As he was doing all of this and they kept like putting the camera towards the expert, I'm like, she's probably diagnosing him right now. She is probably diagnosing him right now because he just won't let it go. He won't let it go. I would love to know what Dr. Warner thinks the diagnosis is for Owens. I would really love to know. Zello says the catch-all question at the end to Sarah Boone was a bit LOL, but she didn't form an opinion either way, so I don't see anything wrong with it. I agree. She didn't give me enough information, and then she didn't go and just make an opinion based on the lack of information. She understands that she didn't have enough time with Sarah Boone in order to accurately make that determination, and I think just going neutral was a good point for her, and it still got across what the prosecution wanted to know, and it went against, and the defense could have explained it away on cross. So I don't think that she did anything wrong. The defense just didn't know how to handle it. He wanted a clear yes or no, and it just doesn't work like that. And if you go to trial, you know that sometimes witnesses give answers that you're not expecting. Kimmy Locker says, so it's a catch-all questions if the psychiatrist asks Boone if there's anything else to share, but hiding the ball if Owens asks if she has any other opinions, and she doesn't lay out everything. Exactly. And there's a way that experts are supposed to be questioned. If you want to answer, ask them a question, because that's simply like, Bree, what do you know about divorce? Well, I know a lot about divorce. What do you want to know? And that's how we conduct our consultations. And that's how we conduct depositions. And that's how we conduct trials. What information do I need to get out to the judge? What information do I need in order to form my opinion, to form my case? And he didn't do that. He dropped the ball, and now he's talking about people are hiding the ball. Well, maybe you should have kept up with the ball, Owens. Maybe it's you. Maybe you're the problem. But no, he'll never think that. Stargazer Kawaii says they had a lot of witnesses come to court only to not testify in this trial. And I know. I'm like, why did y'all call all them witnesses? And I'll tell you the truth, for those of you that watched yesterday, a lot of the witnesses that even testified yesterday, I thought they were pointless. Like I said, Miss Pearl Walker, she was cute. She was cute as heck, but her testimony was a waste of time. We did not need that testimony. She didn't confirm or get rid of anything. She was just on the stand being adorable and not hearing the questions. I don't know what help it was. And she was even shocked that her questioning was over so quickly. So I don't know why they called that lady. And then also the first officer, I don't know why they called her either. I think the defense is just scrambling at this point. And they dismissed a bunch of witnesses yesterday after making them wait at court. Zello Spooth says the last response he wants to strike as a non-responsive was the question they were having the whole argument over. Yes, I did realize that after we kept playing. He basically wanted to argue it a third time. So he argued it 2 times. He was trying to add another one in there. Stargazer Kawaii says, I still wonder if she got him into the suitcase by another means, like I bet or something more her idea than his. I wouldn't be surprised. There's no evidence that has come forward to say that is what she did. But if that came out, I would not be surprised, because guess what? The only 2 people there was her and him. We have no one to ask. Stargazer Kawaii says she had anger, no fear. Agreed. Give Up says, I I wonder too, Stargazer, he did everything she told him to do. Yeah. And it kind of seemed like she was the one with the control, not him. And then with the ex-husband saying that she is an aggressor, I wonder if she was hitting on him too. Stargazer Kawaii says, did he have enough air to make a tone? He sounded really weak in the first video. Yes, exactly. She's going to perceive it as a tone. Because even in those videos where she had the camera and she was kind of getting in his face about it, she probably thought he had a tone. But when I heard the videos, it sounded like she had a tone. She doesn't do anything wrong, though. Destined to Be says that Denied was funny. He was over it. Like, he was denied. And this is the reason. Are you done? It's already been ruled on. Counsel, it's already been ruled. And when you get that counsel, you just pipe down. He did not want to pipe down. Alex P says, that's like when you send a whole long text to someone and they reply with K. Yes. That's exactly what it is. He did that, all that reading. He was reading, flipping them pages, reading. Like, you already read those. And the judge was like, okay. But no, we're not going to do that. We're not going to do that, counsel. Sorry. Kimmy Lockett says the judge said denied quick and in a hurry. And he said denied and to your other motion too. And any other motions you got coming up. One thing I will say is that the defense made so many motions. The state was always like, no, nothing to address. Defense was always like, well, we do have something to address. Y'all always got something to address. Calm down. Like, just stop. But zealous advocacy for Sarah Boone. So she bet not try to appeal for lack of zealous advocacy, lack of assistance of effective assistance of counsel, because he went to bat hard for her. She cannot lie. Mama Bear of One says, hi, friends. Bree, you heard correct. This guy drove his train off into the weeds and led it into a lake being guarded by an octopus that needed said train car over mountains and deserts into the ocean. Yeah. It was a lot. I think he confused himself to the point where they read back the transcript. He was like, I don't think that's what I objected to. You just objecting. You just objecting and you don't know what you're objecting to. Like, come on, dude. Come on. Mama Bear of One says, typo. It should say yesterday not needed. Oh, sorry, I already got rid of it, so I don't know where to correct it. Mama Bear of One says, yeeted, speak to Texas doing me dirty. It's all good. It's all good. Lyd Lee says, the doc asking Boone if there is anything else she wants to tell her is a weird question. Like what? I would be thinking it's kind of asking B to make a mental health assessment on herself. I agree. I was like, what's that noise? I agree with that as well. It's kind of like what the defense tried to do to the expert, and then she turned around and did it to Sarah Boone. The only excuse I would have for her is that she didn't have enough time, and she didn't form the opinion that would be detrimental to Sarah. I mean, I guess the opinion is detrimental if she doesn't find that she had PTSD, but even if she found that she had PTSD, she still would have opined that it had nothing to do with that particular situation. Like, if George was choking her and then she pulled out a knife and stabbed him, and when she stabbed him 47 times, then that is battered spouse, like an overkill kind of reaction. Like, you've been beating me for this long. I'm just going to do it. I'm going to black out and I'm going to do this to you. This was not a blackout situation. This was I'm teaching him a lesson kind of situation. So no, I don't think that she should have done that either. She also should have asked specific questions if there was something she was trying to opine on. But the other thing about it is, like, your expert is not supposed to be biased. So if she was like specifically trying to not diagnose her with PTSD or not diagnose her with certain things, then I probably would say that would lean more towards being biased, right? Mama Bear One says, I can see where it would be weird, but it's no different than going to another doctor's appointment and them asking, is there anything else do you want us to know / concern so that we can help you? Exactly. She's trying, and her interview with this expert was not too long ago. So if she knows an important part of her case is the battered spouse, and she needs to have post-traumatic stress disorder, right? That's what it is. PTSD. That she needs to get this information out. She met with her own psychologist 9 times. She should know the factors that are needed in order to succeed on being diagnosed as PTSD. Not saying she should fake it or anything, but she should definitely give the information that her own expert found were relevant, right? Zello said the most aggressive part was when Owens kept trying to talk over the judge, and he was like, no, let me finish. Like, bro, calm down. Cat Love Dreaming Peach says, I was shocked the judge found something in his favor for this. Yeah, and I was too. I think he was just trying to err on the side of caution. Zello says to Cat Love Dreaming Peach, I'm on the opinion that the judge has been doing everything being deferential and erring towards the defense and a lot to make this verdict error / mistrial / appeal proof. I agree. He does not want to deal with Sarah again. He does not want to deal with her again. Destin to Be says, while you're listening to Owen's rant, take a sec to hit the like button. It might make him stop. Yeah, right. Thanks, Tanya. Mama Bear of One says, was watching with Emily today. It hurt our souls all morning. It just kept going on and on and on and on and on. He just wouldn't stop to the point that was like, counsel, I've already ruled. Stop it. Shut the hell up. That's probably what I was thinking. Oh, wasn't there only about 4 hours total of actual trial today? At least half of this was clowns' objections. I don't even think it was 4 hours with the lunch break. The video was only 9 hours, and then it took about an hour for it to start. I would say probably 2 to 3 hours of actual testimony and videos being shown, but I don't know for sure. Zello says he did ask her if she thought she had battered spouse syndrome, and she did say that she agreed. Exactly. He should have used that. It was what led him to asking her if Sarah was the victim and the biggest mistake. Oh yeah, that's why I said the state cleaned that up really good. She doesn't know if she was the victim. He didn't ask any foundational questions in order for her to even have an opinion whether she was the victim. She doesn't know. And that's what I don't know. How the heck am I supposed to know that? That's what she said, but I don't know. But her husband said she was the initial aggressor and her ex-husband would know, right? So he messed up in letting her get that statement in. Cat Love Dreaming Peach says, he said, does this photo show what happened? Does this photo show who did it? Nope. Yep, exactly. He did it for every single photo and he did a great job at it. Cat Love Dreaming Peach says, I missed the parts where George was the abuser. She said that he stabbed her in the leg with a steak knife. Again, we don't even know that because it's just her telling us. No one was there. She's the only one telling us this. And then she said that he stumped on her face, causing her that black eye. And then she said he dragged her down the stair. So there was a bunch of different incidents, not on this day, but on different days where she's claiming he abused her. Zello says those videos were on her phone and they are being used to rebut her claims of battered spouse syndrome and her being the victim. The defense brought up those police reports / events. Yes. To show that she was not a victim when she was calling the police. So yeah, no, I understand why they got the videos in. But I was saying the mutual abuse, because if we take what she said at face value that he stabbed her, that is abuse. You can't go around stabbing people, right? But also I feel like if he would have stabbed her, he would probably be in jail. But I don't know. She said that she lied on his behalf and he lied on her behalf. And he's over here getting arrested for breaking a no contact order because she called the police. And then they're yelling across the street, I love you. No, I love you. Maybe it's a Romeo and Juliet story. I don't know what they got going on, but it's a different type of love for sure, I would have to say. Cat Love Dreaming Peach says, calm AF on the call, then pretend crying when they were there. Exactly. And some of them, like I said, she was all running up to the police like that was her best friend or her cousin or her husband. Yay, I'm so glad you're here. She asked like one police, can I have a hug? And he was like, no. And then she still proceeded to hug him. It was like really weird. Cat Love Dreaming Peach says, question, isn't taking his license, social security, and birth certificate a felon? Did you see mutual abuse? I saw Sarah as the instigator. I don't know if that's a felony off the top of my head. I don't know if she was hiding it or whatever it was, but she did take it. I don't think, so long as she wasn't using it, I don't know what she could be held liable for other than like stealing something, taking something without permission. But I don't know if it's just a felony to be holding on to someone's documents, right? Unless you're like withholding it from them or you stole it essentially. But so long as she's not, and they could classify as, it would depend on what she's doing with it as to whether it would be a misdemeanor or a felony. But using his license and social security and birth certificate for like benefits and stuff, then yes, that could be a felony probably for sure. Again, it's probably different degrees to like, maybe it might be a misdemeanor, right? It just depends on what's actually happening. I don't have enough information to form an opinion on that. Dr. Warner, cite Dr. Warner. And the reason why I said the mutual abuse is I'm taking what Sarah said he did to her at face value, such as the dragging her down the stairs, the stabbing her in the leg, and the stumping her in the face. We don't know what happened because we can't talk to George, right? But just assuming what she's saying is true, right? Giving her the benefit of the doubt. If he did those things to her, that was not like reactionary to him defending himself against her. We, again, don't know that. Assuming those things are true. And then with watching the videos and the police recordings, that's why I say it's mutual abuse, because maybe she's doing something and he's doing something at different times, which I talked about probably in a pre-record that I still haven't put out because I can't edit. Because I'm not good at editing and it takes me too long, where the court can find restraining orders against two people because each of them were aggressors at two different times, right? Each of them were abusive. Blue says, did you touch on George calling her ma'am? No, I don't think I noticed that in the videos. Zello says, thinking about those actions of making him make those calls, it feels like she was trying to isolate him further from his family. Agreed. And even like the stuff he would say about the family, oh, don't call them, or stuff she would say about the family, oh, don't call them, all of the things, right? Kat says, those other videos also prove she lied that she could only say Those other videos also proved she lied that she could only say what she really felt when he was locked in the suitcase. She clearly said everything she wanted to freely while he was out of the suitcase, and he sat there with his hands down. He wasn't standing. He wasn't getting in her face. The only time he kind of annoyingly reacted back to her is when he was recording her back. And I feel like that made her mad. Like, what'd you recording me for? So yeah, I agree with you. I didn't even make that conclusion, but you're absolutely right. She was saying what she wanted whenever she wanted, and she was always videoing it and putting him in his place. Kat says, didn't Sarah also break the protective order too? So when there's a protective order protecting one person, she cannot break her protective order. It was only against George Torres to stay away from her. There was no contact order that I know of, that I'm aware of, that was stopping her from contacting George Torres. She cannot violate the no contact order protecting her. So she can call him. She can say, hey, come over. She can send him a mail. She can send him a pigeon. She can do whatever. She's not violating the order. The only person that can violate the order is the person that the order is against. So although Sarah might have called him and said, hey, honey bun, I would like to rub on your honey buns, come over. Sarah is not in trouble, but George is in trouble because he knows that no contact order is against him. So even if he would like his honey buns rubbed, he still cannot go over there because he has an order against him, a court order against him, which we saw they were good. She had him over. As soon as she didn't like what he was doing, she had him arrested. She had him removed. She had him taken away. So no, she cannot break the protective order. Zello says to Kat, she can go near him, but he can't go near her, which is weird, right? So she can like follow him around and he has to keep running away. It's weird when you think about it, right? But he can't go near her. He's the one that gets in trouble, not her. There weren't mutual protective orders. He had to stay away from her. Agreed. Yeah. So if he sees her in the store and she starts walking towards him and say, honey bun, I love you, he has to go the other way. He can't love her back, right? He has to just love her in his mind. But for whatever reason they kept doing it. I don't know why he kept doing it. Like after the first time, I would have been like, okay, sis, you out of your mind, you're crazy. You tell me that you love me, and then you're calling the police on me because I didn't get you cereal in the morning. I don't like that. I'm not coming back. But he just kept going back. I'm like, why do you keep going back? She keeps calling the cops on you, and you know the protective order is there. Kat says, oh, here we go. If he can't go near her, then she can't go near him, because if she goes near him, then he would be near her, and that doesn't make sense. It doesn't make sense, but he has to just keep running around. He has to keep running away. Kat says, I love your adorable graphics. Thank you very much. I worked hard on that. Give Up says, it's so cute. First time here. Loved little celebrations. Thank you very much. I'm thinking about doing like random celebrations instead of warning y'all all the time. So we'll see. But thank you. Blue says, for as many times as she called 911, she didn't call the night she had him in the suitcase. I did not even think about that. She sure didn't. For as, buddy she was, wanting to hug, inviting them to the parties. running up to them with her arms out. She sure did not call the police that night. I did not even put that together in watching those videos. You are absolutely right. You can say, hey, look, I did this. But the thing is, the police probably know that they have a history of each of them being the problem. A Stargazer Kawaii says, if this ends with not guilty, I'll be extremely shocked. Now, I wouldn't. I don't think the prosecutor did a good job at putting the case on. I think they left a lot of loose ends. I do. I don't necessarily think that the defense did a good job in defending it. I think that the prosecution didn't do a good job in presenting everything. There's a lot of loose ends. Like even the defense case in chief, their defense had a lot of loose ends. I'm like, y'all are ending already? Like, we just gonna rely on Sarah saying she didn't do it? Like, she didn't mean it? Like, is this what the defense is? And your experts were not even proffered as experts. Same thing with prosecution. Why are your experts not being proffered as experts? What is going on? Like, explain it to me. Tam Jules says, if the facts are against you, argue the law. If the law is against you, argue the facts. If the law and the facts are against you, pound the table and yell like hell. Owens was pounding the table. Yeah. He was like, he will read it and then he'll stand up. It's not fair. Owens, what is your objection? It's not fair, Your Honor. What do you mean? It was what's that one TikTok? Or the one, I think it's from The Office. I don't watch The Office, so if I butcher it, don't judge me for it. Where it's like, it was my understanding that I would not be micromanaged. And he said, oh, what gave you that idea? It was my understanding. That's literally what Owens was doing. It was my understanding. It was my understanding. This is not fair. Your Honor, help me, please. And the thing about it is the prosecution has already made arguments on behalf of the defense in order to not draw things out. Like, are you like, it's time. If anybody needs to be dismissed, it needs to be Owens and his team. Why you got all them lawyers there and y'all still can't get it together? Question from Kat says, is Owens and the other Sarah fans, how is she paying for them? So there was a motion on that. I have not pulled it from the docket yet. They believe that that's what the in-camera review or motion was for that was filed yesterday. I don't know if they've handled it yet because they've been in court so much. And I don't really know what happened this morning, why it took so long for court to start. And I usually watch it on my way to work. But they wanted to know how Sarah was paying for them, because if she is paying for them in a certain way, it may be unethical. So they think that Owens' firm secured the movie rights to Sarah Boone's story or documentary rights to Sarah Boone's story. But I don't know if any orders have came out on that. I'm going to have to look at the docket, but I've been trying to stream every day after the live stream starting Tuesday. I didn't do Monday because I was trying to do pre-records, which those are recorded. I have to release them. I just got to finish editing. And it's hard. I cannot do with the editing. So y'all are just stuck with me live streaming, okay? Because the editing is not for Brie. It's not for me. But anyways, they think that they secured movie rights for her story. And I don't know if there's been an order on that. I'm going to have to look into that a little bit more. Roger W says the defense attorney looks so desperate. He is a mess, just a mess. SS says hands, yellow, heart, red. Oh, those are emojis, yeah. Girl, you on point. Thank you very much. Thank you. Bruna Marches says, what do you think about the witness opinion that battered spouse syndrome was not relevant in the case? I heard people saying that this is a question for the jury and not the psychiatrist. That is what the argument that Owens was making, and we've been making fun of him for the last 2 hours. So what her opinion was that the example that they give, let's say what's the little girl's name that just went to jail? Carly, right? She was trying to plead an insanity defense, right? Saying that she had all of these mental health issues. But at the time of the crime, she hid the knife from the camera. She called her stepdad back because she tried to shoot the stepdad. She knew exactly what she was doing. She texted her friend, hey, you want to see a dead body, right? You're not insane, right? And so what the psychiatrist's opinion is that, yes, she might have been suffering from battered spouse syndrome, but that's technically not justified by what she did, because the facts surrounding the situation, how she was behaving in that situation, does not support that defense. Just like with Carly, her saying she was insane because she had all of these mental health issues are not supported because she did all of these things to kind of hide the evidence and laugh about it with her friends and trying to show her friends a dead body. So she wasn't necessarily saying that it's not relevant to the case. She's saying that it's not supported by the defendant's action. So maybe she could have worded it better so that it wasn't as confusing, but that was literally the argument that Owens was trying to make. Psychiatrist saying it's not supported by the facts, not necessarily that the jury cannot find that. The jury can still say that psychiatrist didn't review nothing. She doesn't know what the heck she's talking about. She didn't even get enough information. She only met with him an hour and a half. We're going to disregard that therapist. They can do that. So no, she was not telling the jury, you have to rule like this. And the court cited the authority that it relied on. I don't think it's going to be, I really don't think that it's going to be an issue for the case. So I hope that made sense. The facts are not supported by better. She may have it on other times, right? Like if he would have stabbed her and then she would have slit his throat, then yeah, maybe better spouse, right? Self-defense. But in this particular situation, no. And I agree with the court. I don't think that the psychiatrist was trying to tell the jury what if she was justified or not. They were just saying that the facts do not support it. Look how happy they were. And that's been the defense's position the entire time. Kat says, all Sarah's words against the man she killed, we cannot talk to him. We don't know what his opinion is. We don't know what he would have to say. We got Stargazer Kawaii saying, it always gets me that she wanted the police to look at her phone. I'm like, because she said she forgot. She said she forgot. She probably wouldn't have done that if she didn't forget, but they would have eventually got a search warrant for it. Tam Jewel says, I can honestly say I would never hug a cop, but she wanted to hug them multiple times. I don't know why. Mailman, love the name, says he got into trouble masturbating. Yeah, she was filming him like, look what you did. You're so bad. Why would you watch porn? It's like, dude, why are you recording him having this conversation? Tam Jewel says the hardest thing for me to see how beaten down he became over time. Yes, over time. Near the end of the videos, his body language just screamed he was so diminished as a man and dominated into submission. It's heartbreaking. And then the other thing about it is that she was probably also financially abusing him, in my opinion, because he was not making as much money as she thought he should. She probably felt like she was taking care of things. She was saying that he was feeling bad because he lost his job. It honestly, after watching the videos, after watching her testimony, after watching her position, it would not surprise me if she was the one like, oh, you're broke, you lost your job, you already don't contribute enough money. I could see her doing that. Like, I really could. Mailman says, yeah, I bet a lot of people cried in court TV. Yeah, you can definitely see it going downhill. And it does not seem like he was the aggressor. It seemed like she had the coercive control. And I think that's what the prosecution was trying to show, because they brought it up throughout the trial. A man can be a victim, right? A man can be a victim. And was he reacting to her? And that's how she got the black eye, because he defended himself against her. That would be the question. And then he was a small guy. So maybe she thought she could take him. And so she would try to take him. I don't know. Bruna says, the video where she said the same, that is my name, don't wear it out. Oh, that gave me chills. From the suitcase video was chilling. Yeah, that gave me chills. It was chilling. My jaw was on the floor. Yeah. It's like she does this all the time. And it's like, I haven't heard that saying since I was a kid, and she's still using it. And I feel like that was a part of her control method of him trying to communicate with her and him saying her name. Oh, that's my name. Don't wear it out. Like, I'm too good for you. Stop, talking to me. I'm above you is what it came off as. Kat says, my theory is that George was taking the suitcase out of the closet so he could leave her once and for all. And that's what happened because of it. But that's my theory. Oh, that's an interesting theory. Haven't heard of that one, but it's plausible in my opinion. Mailman says almost everything she says, it turns out to be opposite. Yes, I agree. She lied then. She wants us to believe that she lied to the police, but she's not lying to us now. She also wants us to believe that she doesn't remember what happened before she started videotaping. And then she wants us to believe that she doesn't remember what happened the 9 minutes before the videotape, but she remembers the 12 minutes after the videotape. It makes absolutely no sense. She couldn't possibly keep up with this many lies. She cannot simply keep track of what she said. I agree. And I think that's why a lot of the attorneys that actually worked with her for a long time that had to dismiss her, she was probably going for this theory and they was telling her no, but Owens is willing to do it for her. Kat says, do you think when Sarah gets carded When she gets carted away in chains, she'll yell, "Why are you doing this to me? Why is this happening? You're trying to make me seem like I'm someone I'm not." Probably. Why are you handcuffing me? Why am I being arrested? And that one video where she was like, "Are you arresting me? Are you arresting me?" And the cop's like, "Did you do something that I should arrest you for?" She's like, I don't know, because last time they arrested me and I didn't do anything wrong. Yeah, you probably did something wrong at this point. Kat says, "I need another client to edit videos for if you need help." Oh, can you edit videos? Because I'm so bad at it. Let me know. Sasha Wells says, "Call it quits and put this lady in jail already. Waste of taxpayers' money." I'm concerned that the prosecution didn't do a good job. Like, if she's not convicted, I won't be surprised. If she's convicted, I'll be very happy. Mailman says, "Sarah Caitlin Boone, your pants have been on fire." Yeah, liar, pants on fire. Kat says, "Also so creepy, she kept asking the other cop to sit on the couch. And like, hey, you should come hang out." It's like, why? You be fighting your boyfriend. I don't want to be over here. Tam Joel says, "It triggered me heavy today. I cried for George never being hurt." And it does seem to me like she had the control. Sarah Wells says, "Sarah is nutty than a fruit basket." Who tries to hug a cop even after he said no. And she still did. She literally still, and you can see the cop like putting his hand out like, excuse me, back up. I'm good. You're being weird. Mailman, and like he has a gun on him. He has a taser on him and you're trying to hug him. Like, what's going on? Mailman says, "I think she has a thing for cops because she sees them as the highest authority." And she keeps calling them. And then Sasha Wells says, "She texted the brother, 'Hide and seek I shall.' Crazy fool planned the whole stupid thing." And yeah, and then like, "I'll get rid of him." Like, that stuck with me. I hope it stuck with the jury, right? I think she was setting him up. That's my opinion, and I'm sticking to it. Anyways, we are done with the live stream for today. Thank you everyone for joining me live. If you haven't already, please do hit the like button and subscribe if you made it this far into the live stream. I was not planning this long of a live stream, but it ended up this long, but it was fun. It was informational, in my opinion. How am I saying my own stream informational? I am still going to try to stream tomorrow after work, just doing a recap. We will not be doing full live streams over here of the whole trial, but I will try to do a recap and get back to y'all tomorrow. Tomorrow we will be live around 7:00 again, probably around 7:00, unless I get off early. Yeah. But anyways, thank you everyone for joining the live stream. I will see y'all all tomorrow. And